Good morning to all of honorable guests, ladies and gentlemen. We would like to inform you the rule during this event as follows. To set your mobile phones into silent mode during this event and no phone calls inside the rooms. To access the conference program and panelist presentation, you can access the Linktree with ballroom Wi-Fi connection. This event is live streamed through YouTube and documented for publication purpose. The translation device is limited for English to Indonesia, and Indonesia to English are provided by request to the translator desk. And please, return the device in after the session ended. Alternatively, you can access translation through Zoom, link provided in the link tree. In the end session, please fill the evaluation form or survey, which also could be accessed in the link tree. Thank you for your cooperation and understanding. Assalamualaikum warahmatullahi wabarakatuh. Shalom, Om Swastiastu, Namo Buddhaya, salam kebajikan, dan salam sejahtera bagi kita semua. Ladies and gentlemen, good morning and welcome to the Southeast Asia National Human Rights Institution Forum SEANF Regional Conference 2025. My name is Milenia Patricia, who will be your master of ceremony of today. It's such a great honor to have your presence today. Before we begin, may I invite everyone to stand up for the national anthem of the Republic of Indonesia. Thank you very much, and please be seated. We would like to extend our warmest welcome to SEANF delegates. Good morning to National Commission on Human Rights of the Republic of Indonesia, Komnas HAM. Chairperson, Mrs. Anis Hidayah. Vice Chair, Mr. Prabianto Mukti Wibowo. Commissioner Adnika Nova Sigiro. Commissioner Abdul Haris Semendawai. Commissioner Uli Parulian Sihombing. And to all delegates from Komnas HAM. And good morning to Human Rights Commission of Malaysia, Suhakam. Vice Chair, Datuk Mariati Robert. And to all delegates from Suhakam. And good morning to Myanmar National Human Rights Commission, MNHRC. Chairman, Pauline Sein. Commissioner Dr. Tan Min. And to all delegates from MNHRC. And good morning to Commission on Human Rights of the Philippines, CHRP. Commissioner Faidah Maniri Dumarpa. Commissioner Monina Arevalo Zenarosa. Commissioner Beda Angeles Epres. and to all delegates from CHRP. And good morning to National Human Rights Commission of Thailand, NHRCT. Chairperson Pron Prapai Ganjanarit. Commissioner Supatra Nakapeo. And to all delegates from NHRCT. And good morning to Provedoriados Direitos Humanos e Justica PDSJ of Timor-Leste. Ombudsman Virgilio da Silva Guterres. Deputy Ombudsman Chair Maria Marilia da Costa. And to all delegates from PDSJ. And good morning to honorable panelists of the conference and distinguished guests from ministries and agencies of the government of Indonesia. Embassies, regional bodies, and international organizations, civil society organization, university and academics, corporate and business association. We welcome and appreciate your attendance to this event. Before we begin the conference, allow me to briefly introduce the Southeast Asian National Human Rights Institution Forum, or SEANF. SEANF is a cooperative body established in 2007 to strengthen collaboration and share best practice among national human rights institutions in Southeast Asia. Its membership comprises 6 institutions: Komnas HAM Indonesia, Suhakam Malaysia, the CHR Philippines, the NHRC of Thailand, Myanmar NHRC, and the PDSJ Timor-Leste. SEANF holds an annual conference, hosted in rotation by its member in alphabetical order. This year, Komnas HAM Indonesia is honored to serve as SEANF chair and to the host annual conference. As part of 22nd SEANF Annual Conference 2025, Komnas HAM convenes the Regional Conference on the Human Rights in the Digital Space, Emerging Challenge and the Role of NHRIs. This conference aims to explore both the opportunities and challenges posed by digital technology on human rights, and to highlight the role of national human rights institutions in promoting a right-based digital transformation in the region. Before we proceed with today's agenda, let me read our agenda for today. There will be 5 agenda items for today, and please allow me to read it. Firstly, unwelcoming speech by Chair of Komnas HAM, and followed by video statement by Indonesia representative for ASEAN Intergovernmental Commission on Human Rights, ACER 2025 to 2027. Then, we will take a coffee break and photo session. After the break, we start with first session which discussing promoting protection of freedom of expression. We will break for lunch and will continue for second discuss with topic practical application of the UNGPs to the activities of technology companies, including AI and data protection. And the third session will discuss topic human rights protection in digital space of vulnerable groups. Before ending this conference, there will be the reading of SEANF Conference Statement on Human Rights in the Digital Space by SEANF members. And then we will officially close the SEANF Regional Conference 2025. Ladies and gentlemen, now we are going to the first agenda. We would like to invite the chairperson of Komnas HAM, Madam Anis Hidayah, to deliver welcoming speech. So please give the warmest applause.
Assalamualaikum warahmatullahi wabarakatuh. Good morning. Selamat pagi, Honorable Ambassador of Timor-Leste to Indonesia, Chairperson, Commissioner, and all delegates from National Human Rights Commission of Thailand, Provedor and Ombudsman, and all delegates from Provedoria dos Derechos Humanos of Timor-Leste, Vice Chairperson and delegates from Suhakam, Malaysia, Chairman, Commissioner, and all delegates from Myanmar National Human Rights Commission, Commissioner and colleague from Komnas HAM, Honorable distinguished guests, colleagues, and friends. It's an honor for me to address distinguished guests, colleagues, and participants at the SEANF Regional Conference on Human Rights in the Digital Space, Emerging Challenge and Role of National Human Rights Institutions. Allow me to extend a warm welcome to SEANF members, representatives from embassies, UN offices, Indonesian ministries, and state institutions, academia, and human rights defenders here in Jakarta. Ladies and gentlemen, the situation of human rights protection and fulfillment, particularly in Southeast Asia, has entered a new chapter, one where human rights issues and challenges no longer occur only in the physical world, but also increasingly unfold in the digital space. Alongside the rapid growth of internet use and digital transformation across the region, the realization of human rights faces a complex turbulence, bringing both positive and negative implications. In this context, the rapid development of the digital technology has brought major change to human life, including how people interact. While it offers new opportunities for participation and free expression, it can also be used to monitor, control, and restrict these freedoms, thus shaping the quality of democracy itself. In the digital space, challenge to freedom of expression in Indonesia and also in Southeast Asia come from policies that fail to respect people's rights to express in their opinion, and from a lack of clear regulation to ensure safe and fair use of technology information. Gender-based online violence is another issue, with Komnas HAM receiving almost 500 complaints from 2002 until 2024, mostly about women's safety and rights. These problems are made worse by low digital literacy, with many people tricked by hoaxes into giving away personal information, little understanding of data privacy, and unclear rules about AI use. And this creates fear among people to freely express in their opinion online, known the chilling effect. This is dangerous in a democracy because it blocks civil rights like free speech, assembly, and expression. The chilling effect can happen due to vague laws, harsh law enforcement, or social and political pressure. The democratic regression is reflected in the number and types of freedom of expression violations that reported to Komnas HAM over in the past 5 years. In the context of human rights promotion, digital technology have made education, outreach, and policies advocacy more effective and accessible. Human rights promotion can now reach a broader public base through digital engagement. Various experiences across Southeast Asia have demonstrated how digital activism plays a crucial role in nurturing awareness and strengthening the spirit of human rights protection and enforcement within societies. Ladies and gentlemen, however, in the same time, the enjoyment of human rights is often violated within digital space. Instead of serving as a safe and inclusive arena of democracy, the digital realm sometimes fails to protect civic freedoms. The suppression of freedom of expression and opinion has frequently become a defining issue in many countries. Human rights defenders also continue to face restriction and threat from actors who should in principles be responsible for upholding those rights. We often hear of human rights defenders suffering from judicial harassment, intimidation, physical or verbal violence, and even killing, all streaming from or taking place through digital media. Moreover, vulnerable groups are disproportionately affected by digital human rights violations. Practices such as an online scam, doxing, and the spread of misinformation or disinformation often target women, an elderly person with disability, and children. With the rapid development of artificial intelligence, the risk of discrimination and bias have gone significantly, making it urgent to establish human rights-based regulatory and policy frameworks that can effectively address this emerging challenge. National human rights institutions hold a unique and essential role in safeguarding and monitoring the realization of human rights in digital spaces. Through their mandates and function, national human rights institutions can act as partners of civil society, non-state actors, and government in creating a more enabling environment of human rights online. Therefore, strengthening in independency of impartiality of national human rights institutions is a crucial foundation for addressing the increasingly complex human rights potentials and risks in the digital sphere. This conference serves as an important moment for us to reflect on the state of human rights protection, respect, and fulfillment in the digital domain across Southeast Asia. It is also a platform for us to exchange the perspective and, more importantly, to unite our hearts and voices in the pursuit of more inclusive and effective human rights enforcement despite our diverse background and national context. Through today's discussion, I hope we can further deepen our understanding of each stakeholder's role, particularly among national human rights institutions, government, civil society, and a state across so that meaningful, collaborative, and collective efforts can be forged. May the actions we have shared in this conference inspire concrete steps in our respective countries and strengthen our collective resolve to promote, protect, and ensure human rights for all, including in the digital space. Thank you very much. Wassalamualaikum warahmatullahi wabarakatuh. Good morning.
Thank you very much to Madam Chairperson. Next agenda, we will watch the video statement from Her Excellency Anita Asvini Wahid as Indonesian representative for ICER 2025 to 2027.
Excellencies, distinguished chairs of SEANF, honorable commissioners of national human rights institutions, colleagues, ladies and gentlemen, good morning. It is an honor for me, on behalf of the ASEAN Intergovernmental Commission on Human Rights Indonesia, to address this milestone gathering of SEANF. I extend my sincere appreciation to SEANF for hosting this regional conference on human rights in the digital space. The digital transformation of our region is moving at extraordinary speed, reshaping the way our societies function and how our people experience their rights and liberties. This forum comes at a critical moment. As Southeast Asia becomes increasingly digital, new opportunities emerge, but so do new vulnerabilities. The theme of today's conference, Emerging Challenges and the Role of National Human Rights Institutions, reflects the urgent need for regional institutions to adapt, innovate, and cooperate. Excellencies, allow me to begin by sharing ICHR Indonesia's view on the current landscape of human rights online in our region. First, freedom of expression and opinion continues to expand online, yet it is also increasingly challenged. Online harassment, coordinated digital attacks against journalists and human rights defenders and critics, and opaque moderation systems threaten open civic space. Second, the region faces rising concerns over privacy, data governance, digital surveillance, and AI-driven technologies. Many people remain unaware of how their data is collected, used, or monetized. The rapid adoption of artificial intelligence, biometric identification, and algorithmic decision-making requires stronger safeguards and clearer accountability. Third, digital inequality persists. Access gaps, affordability barriers, and limited digital literacy disproportionately affect women, rural communities, indigenous peoples, children, persons with disabilities, and migrant workers. These gaps translate into unequal protection and unequal opportunities to claim one's rights. Fourth, the side effect of all the digital malice that persists within the digital space, such as cyberbullying, disinformation, doxing, harassment, and others, have been recorded to affect mental health of Internet users that threatens the right to health. Fifth, and of particular relevance to our institutions, is the rise of online exploitation and cyber-enabled trafficking in persons. Trafficking networks increasingly use digital platforms to recruit, deceive, and control victims. Online fraud compounds these harms, and victims are often criminalized for acts they were forced to commit. These developments paint a complex picture. Digitalization brings empowerment, but at the same time also deepening social and human rights risks. This is the reality Southeast Asia must confront collectively. Ladies and gentlemen, in responding to the evolving digital landscape, ICHR Indonesia has sought to strengthen protection for those most vulnerable, particularly victims of trafficking in persons, including victims coerced into crimes through online means. In June this year, ICHR Indonesia, in collaboration with SOMTC Philippines, launched the ASEAN Guidelines on the Implementation of the Non-Punishment Principle, or NPP, for victims of trafficking in persons. This is a landmark achievement for our region. It reflects ASEAN's growing understanding that victims of trafficking, regardless of whether the exploitation occurs offline or through online schemes, must not be punished for unlawful acts committed as a direct consequence of their exploitation. Today, forced criminality is increasingly linked to digital environments, to online scamming rings, to cyber-enabled forced labor, to fraudulent recruitment through social media, and to exploitation in online gambling or cyber fraud compounds. In many of these cases, the digital entry point is also the point of coercion. The NPP guidelines therefore become even more relevant in the digital age. They provide clarity on legal obligations, encourage the adoption of trauma-informed approaches, and guide authorities in distinguishing between perpetrators and victims, especially where digital tools blur these boundaries. To ensure that these guidelines become practical and implementable, we have embarked on two important follow-up initiatives. The first one is developing victim screening indicators for frontline personnel. ICHR Indonesia, and again with SOMTC Philippines, together with ASEAN member states, are designing indicators that help investigators, immigration officials, police officers, and labor inspectors identify potential victims of trafficking in digital settings. These indicators address signs of online coercion, digital debt bondage, manipulation by online syndicates, and the use of technology to isolate or control victims. The second initiative is drafting comprehensive training materials for practitioners on the ground. We are working toward practical modules that support law enforcement officers, social workers, labor officials, and border authorities in implementing the NPP consistently and sensitively. The training materials will cover digital recruitment patterns, trauma-informed interviewing techniques, cross-border referral pathways, and coordination between NHRIs, police, and service providers. These efforts illustrate Indonesia's belief that human rights protection in the digital environment must be holistic, addressing not only civil and political rights online, but also the rights of victims coerced into criminality through digital exploitation. Distinguished participants, beyond trafficking, Southeast Asia faces broader questions about how to safeguard human rights in the digital age. ICHR Indonesia believes it is time to explore regional instruments, guidelines, or principles that address digital rights comprehensively. There are clear opportunities to develop ASEAN-level frameworks on protection of freedom of expression online, data protection and digital privacy, algorithmic fairness and transparency, responsibilities of digital platforms, online safety for children, cross-border digital cooperation, and safeguards against AI misuse. The momentum is growing. ASEAN has already adopted the Declaration on the Rights of the Child in the Digital Environment and continues to implement the ASEAN Digital Master Plan of 2025. Building upon this, we can explore more targeted human rights-oriented instruments that reflect our region's unique challenges. ICHR Indonesia stands ready to continue initiating studies, stakeholder dialogues, and cross-pillar engagements to advance this agenda. Colleagues, the digital environment cannot be governed by governments alone. Its complexities demand multi-stakeholder cooperation. We need partnerships with NHRIs, civil society organizations, academia, technology companies, and international human rights mechanisms. Every actor holds a piece of the solution. ICHR and SEANF, in particular, share a natural complementarity. ICHR, as an ASEAN's human rights mechanism, advances regional norms and fosters intergovernmental cooperation, while SEANF, representing the region's NHRIs, offers grassroots awareness, complaint mechanisms, monitoring capacity, and deep links to affected communities. This complementarity is crucial for digital era human rights. Our collaboration can support joint monitoring of online harms, trafficking, and cyber-enabled exploitation, shared insights on digital rights regulations and best practices, cooperation on early warning for online-enabled violations, capacity building for frontline responders, and the mainstreaming of the non-punishment principle across digital-related cases. ICHR Indonesia strongly supports deeper collaboration with SEANF, especially in operationalizing the NPP guidelines, refining digital victim screening tools, and advancing common human rights standards for digital governance. Distinguished guests, the digital world is rapidly expanding. Whether it becomes a space of empowerment or exploitation depends on the decisions we make today. Let us ensure that human dignity remains the foundation of digital development. Rights offline are fully protected online. Marginalized groups are not left behind. Victims of digital exploitation are protected and not punished, and regional cooperation remains strong and forward-looking. Indonesia is committed to working with SEANF, ASEAN member states, and all partners to build a digital future where innovation strengthens human rights and where no individual's dignity is diminished by the technologies we create. Lastly, I wish you a very productive and fruitful conference, and I'm looking forward to our future collaborations. Thank you.
Respective colleagues, we would now proceed to the photo session from the stage. May I invite all commissioners from SEANF member to stand in front of the stage. And please, to all meeting participants, to stand up. Let me inform you, May I invite all commissioner from SEANF member to stand in front of the stage, and please, to all meeting participants to stand up, because we're gonna take a picture for a moment, and please take a place look at the camera and give your best smile. On my count, in 3, 2, 1. Once more. In 3, 2, 1. Thank you very much. Please be seated. Ladies and gentlemen, we would now come to a short coffee break for about 15 minutes. Refreshments are available at the foyer in front of the ballroom. And please, kindly return to your seats by 10:15 as we will resume the session promptly. Thank you. Please, enjoy your coffee break. To all participants, we kindly ask you to enter the ballroom and please take a seat, as our event will begin shortly. Thank you very much. To all participants, our first session is promoting protection of freedom of expression. To lead this session, may I invite Mr. Virgilio da Silva Guterres, the chairperson of PDSG. Mr. Guterres is the current ombudsman of Provider for Human Rights and Justice at the PDSJ of Timor-Leste. Serving a 5-year term from 2023 to 2027, Mr. Guterres built his professional career in journalism starting in 1998 as he co-founded Revista Talita Kumrod in Tetum for Hori Otas Horiwain and later served as Director General of Timor-Leste Radio and Television from 2004 to 2006. He also held leadership roles in media governance, serving as president for the Timor-Leste Press Council from 2016 to 2022, and again in 2021 to 2022. So please, Mr. Guterres, the floor is yours.
Thank you, MC. It's not just an honor, but also a blessing to chair this first session. So, honorable chairs, delegates, and distinguished guests, ladies and gentlemen. When I was still as a journalist, I joined a training, first aid training. Even the first aid training was provided during the period of when we are still in the schools or in the Boy Scout. So in that training, we were advised, or we were trained how to identify if someone is a survivor of an accident or a dead body. So two places of a human body that we want to test. The first is your nose, and in this part, to feel that if still breath. So when you feel that still breath, then the hope to survive is there. And in the first place, if you don't have any sign of breath, the second place is the heart. If it's still beating there. So this was these two important parts of our body to be tested to identify if someone is a survivor of an accident or a dead body. I came up with this experience to justify the statement of the then UN Secretary General, Kofi Annan. I think his image was appeared in the video show this morning, stating that when we talk about democracy, two things it's important: freedom of the press and freedom of expression. And at that time, Dr. Kofi Annan was saying that freedom of the press is the breath of democracy. If in a society, if you still have a free press, there's a hope that democracy is still alive there. And then the freedom of expression, Dr. Kofi Annan named it as the heart of the democracy. So this session, we are talking about to find out if we are still breathing or our heart is still beating inside. So I was blessed because I will share two of our strong ladies from two, I think, very dynamic society, Indonesia and the Philippines, as the big brothers of ASEAN, or big sisters, to be gender balance of ASEAN. And freedom of expression, philosophically, I think it was the essential part that differ us as human from other living creatures. Because the process, I don't read Darwin about the evolution things, but someone said that the human being struggle is from the reptile way, scrolling to stand up, it's just for that, to be free to express its existence. So when we go in the front of the mirror, the first to find if we are handsome enough, beautiful enough today, but in some parts, also to find that my head is still on my shoulder. So the way we struggle is to maintain that we still stand up, not scroll again. So that's why my session will be talking about very important part. So without any further ado, I will introduce to you our distinguished speaker. Speaker one, Dr. Atnike Nova Sigiro. Dr. Atnike Nova Sigiro currently serves as a Commissioner of the National Human Rights Commission of the Republic of Indonesia, Komnas HAM. She also teaches at the Postgraduate School of Diplomacy, Paramadina University in Jakarta. She earned her doctoral in social welfare from the Faculty of Social and Political Science, University of Indonesia. Master in Social Policy and Development from the Department of Social Policy of the London School of Economics and Political Science. And BA, Bachelor of Art in Social Welfare from the Faculty of Social and Political Science of University of Indonesia. She has engaged in human rights advocacy in various avenues, namely at the UN Human Rights Council, ASEAN Human Rights Mechanism, and also in Indonesia. She also worked with NGOs in Indonesia and Asia. So let's welcome Dr. Atnike Nova Sigiro with big applause. Our second speaker, Commissioner Faida Maniri Dumarpa. Commissioner Faida Maniri Dumarpa is a member of the 6th Commission and Bank of the Commission of Human Rights, CHR, a passionate advocate for justice and equality. Her work is dedicated toward advancing gender rights, protection of marginalized communities, and ensuring human dignity in both traditional and emerging spaces. A Maranao Muslim lawyer, Commissioner Dumarpa previously served in the House of Representatives, the Senate, the National Power Corporation, and the National Nutrition Council. She brings to the Commission expertise in governance and policy, enriching the Commission leadership with competence, cultural diversity, and a steadfast commitment to justice and equality. So please, let us welcome Commissioner Faida Maniri Dumarpa. I will not take my time anymore to do some. I will keep that time for the closing. So we have more than 1 hour. I think 1 plus 15 minutes hour for us. We will have, after the presentation for the speakers, I think 10 to 15 minutes will be sufficient for each speaker to present their ideas. And then after the presentation of all the speakers, we will have Q&A session. And if, depending on the time that we have. So now I will follow the order written in the agenda. So the first opportunity I will leave to Dr. Atnike to present her views on the issue. Please.
Thank you, Professor. Thank you, Professor Guterres. I always call him by name, Maunjil. But today is a formal session, so I have to call him by his designation in PDHG. And good morning, Attorney Faida. We share the same panel in less than 1 week. Last week we spoke together in the Asia Pacific Forum for National Human Rights Institution Forum in Fiji on environmental issues and human rights. Now on digital. We are going from the nature to technology. So I have about 10 to 15 minutes rights to speak. And that is not a limitation of rights, that is democracy, to give others the same space to speak as well, including participants of the conference. And on behalf of Komnas HAM, I'm so happy that the round is full with all participants from NHRIs and also civil society, academics, and ministries in Indonesia, and also colleagues from other journalists, corporations, technology companies, who share the same concerns of the growing use of internet technology, digital technology, in advancing human civilization. But we understand that there are always two sides of a coin. So I think that is the first session is all about. We are going to see what are the two sides of the coin of the digital technology that we face all together, not just Southeast Asia, but I think globally, internet technology is something that we cannot left out from our daily life. Although we understand there is a digital gap where some people doesn't or do not have the same opportunity or do not have the same understanding, literacy on what our digital rights is all about. But my presentation will not talk broadly about those issues because that would be impossible to exhaustive. I would like to concentrate on the issue of human rights defenders in digital space. Why? Not that it is the most important, but it is important because human rights defenders is the safeguards of human rights who pioneer advocacy, who give awareness, who have more sensitivity on what is going on with human rights of others. So therefore, I would like to concentrate on the issue of human rights defenders in my presentation. Next slide, please. I will not explain everything about my slides. I hope all participants will get the presentation about Komnas HAM. You can read it by yourself. I think similar to other commissions, we have a mandate or function in ensuring protection of human rights, promotion of human rights, working with civil society, working with governments, but also watch how the state, the government as duty bearers implement their duties. We understand that digital technology, next slide please, has created a new space. I think in the previous speeches, it was mentioned how digital space technology creates opportunity for jobs, creates opportunity to connect from among other parts of the world. We never imagined that in the past or 20 years ago, we could never imagine that we could do a video call through our mobile phone, but now we can do that. It creates new public space and also in a way open up and broaden democracy and freedom of expression. It offers both potential and risks, as we all understand. There are new crimes, there are new politics using digital technology. But it at the same time also creates human rights work. We have now activists doing mainly on digital technology to campaign, to educate, and to advocate for a better human rights. We have cross-border creativity, especially in Southeast Asia. There are several initiatives among the youth, among human rights defenders, among civil society organizations, and also among governments in improving human rights, in improving democracy in this part of region of the world. But we understand there is a growing risk to freedom of expression in the digital space. This is probably that organization or institution like the National Human Rights Institution paying attention for, especially in this conference. We understand there is a need for stronger protection mechanism because challenge, risks, and threats are no longer in the physical space, but in the digital space. We can communicate with others, but we never know what others experience. For example, when someone breach your data privacy, when someone docks your information, private information, and so on, or bully you in your internet or email account, social media account, you may not experience it unless you experience it yourself. And this happens in many cases towards or against human rights defenders. We need a responsible governance, not just a responsible government, but responsible governance. It means it requires regulation and body to monitor how the regulations are implemented, how business sectors operates in advancing the use of digital technology, creating profits from digital technology. And it requires active role of all stakeholders, which we are lucky that we are going to have many stakeholders here, not just government, civil society, but also technology companies. Global framework have provided so many instruments for human rights, and now increasing also on the use of digital technology. I'm not going to explain one by one. This is for you later to explore more. What is interesting, in the past, I think 10 or at the most 2 decades, there is a growing creation of digital activism. Maybe among the SEANF countries, later we can share what kind of digital activisms emerge in your country. In Indonesia, there are several cases where human rights defenders are being challenged or attacked, or regulation are being drafted in the legislative body, or when political situation push the communities or the people to stand up and voice what they want from the government or from the politician. We have reformasi di korupsi. This is, I think from the words you can know, it's issue on corruption in Indonesia. We have hashtag Bebaskan Haris Fathia, which is about how to free human rights defenders at risk. And also, these trends happen at the global level. We see how the Me Too movement against violence against women emerged in social media in the past few years ago, and just recently we have Eyes on Palestine and other issues at the global level. I think the same situation, the same innovation and creativity also happen in our countries among the SEANF members. Digital activism in Indonesia also helps to monitor how policies are implemented. For example, in the period of pandemic, there was an initiative of Lapor COVID, means report the COVID. It's an initiative created by civil society in order to follow what is needed to be paid attention by the government. Also, when general election took place, civil society also create application or content to monitor how general election was held. So these collective digital movements have significantly improved public access to relevant and reliable information, at the same time provide avenue for people to express their opinion on different issues, not just politics, economics, but also other issues. However, in the context of Indonesia, the advancement of digital technology and communication also coming along with the challenge. For example, the regulations exist in Indonesia is still limited. And the existing regulation in some cases were interpreted negatively against human rights defenders of freedom of expression. We are still facing the blocking of content with no clear indicators of regulation,
in what aspect or in what condition can internet content, social media content can be blocked or deleted from the account. We have shutting down internet access the same as blocking content or deleting content without a clear standards and procedures in doing so. We have forms of challenges and threats against freedom of expression, particularly against human rights defenders. The first, I think this is known also to others, judicial harassment, where activists were arrested on various grounds, such as defamations or treason, including allegation of inciting unrest through online platform or online activities. We have human rights defenders and also individuals being bullied, including the form of gender-based violence online against women human rights defenders. And we have faced also challenges and attacks such as hacking of WhatsApp account, email, and also doxing, spreading your private information to public in order, of course, to intimidate the person. From 2020 until 2024, Komnas HAM handled several forms of challenge or attacks against freedom of expression, from threats such as threats and intimidation in academic forum, arrest and detention of individual participating in demonstration, judicial harassment under the internet, transaction and electronic law, and also policies restricting public expression. The law on internet and electronic transaction is one of the laws in Indonesia which has been used so often to criminalize or to harass someone, including human rights defenders. I would like to give some examples. I don't want this forum to be so gloomy. There are challenges, but as long as national human rights institutions make most of the efforts to deal with such cases and challenges, I think there are some examples where we can address and cope with the situation. The first I would like to share here, this is Fathia Haris. They are human rights defenders in Indonesia. They were prosecuted under the Internet and Electronic Transaction Law for alleged defamation due to their talk show in YouTube account. So this is digital activism where people use YouTube, Instagram, Facebook, and so on to share their thoughts and opinion about certain issues concerning human rights. After they were prosecuted, Komnas HAM issued human rights defender certificates to state that what they do and themselves are human rights defenders that conduct or hold or held the talk show as part of human rights advocacy. Komnas HAM emphasized that what they do is part of public interest advocacy on environmental rights, and therefore it should be not only respected but also protected. In 2024, the East Jakarta District Court acquitted both defendants and restored their rights. This case could reach to that decision because there were a wide online support in social media for their cases as well. So this is not just a contribution of Komnas HAM, but the whole civil society, including government agencies who understand that human rights defenders should be respected and protected. The other issue that increasingly get a challenge in terms of advocacy now is on environmental issues. Indonesia is a very huge country with lots of land and natural resources, and there are many projects on exploitation of natural resources and so on, and therefore, of course, as the consequences, there will be disputes on natural resources in Indonesia. One of the cases that was handled by Komnas HAM was to Daniel Fritz Maurits Tangkilisan. He is an environmental activist, was charged with hate speech, again under the Internet and Electronic Transaction Law for criticizing environmental damage. Komnas HAM found that the case is a form of strategic litigation against public participation, or SLAP in acronym. I think the issue of SLAP is also something that is shared globally, that many activists are being prosecuted for their advocacy. But the SLAP can be used on the basis of the content that are shared in internet. Although you demonstrate or conduct peace assembly outside, sometimes you don't know that the content was captured in social media, shared in internet, and the prosecution was or were made based on the content in the internet, not on the actual physical assembly, for example. So this is how the digital technology now are being used against human rights defenders. The third case is on women human rights defenders. This is also challenging, and I think this situation is also shared by others in other countries. A human rights lawyer who assists victims of sexual violence were reported for defamation by others using the Internet and Electronic Transaction Law, because she was conducted a press conference where she made statements on the case that she assisted upon. Similarly, for the three cases, Komnas HAM issued a certificate of human rights defenders in order to convince authorities, including law enforcement officers, that to support what they do as part of human rights advocacy or human rights participation. The case was also dissolved by the court for this women human rights defender. For women human rights defenders, attack against them undermines both their freedom of expression, but also victims' access to justice. Because as a lawyer, if you can be prosecuted for what you do as a lawyer, it means the victims will not get help by lawyers in the future. Aside from dealing with actual cases on human rights defenders, Komnas HAM also conducted research. This is one of the functions shared by NHRIs. We conducted research on issues concerning digital technology and information, and also freedom of expression. For example, on the law of internet and electronic transaction, Komnas HAM conducted several studies. The first in 2022, Komnas HAM recommend revision to safeguard freedom of expression, proportional limitation, shifting defamation to civil law, and assigning internet shutdown authority to an independent and transparent body. In 2024, also, Komnas HAM prepared or released a policy brief on the internet and electronic transaction law, emphasizing the need for anti-SLAPP mechanism to prevent criminalization for those exercising human rights advocacy. Komnas HAM also produced a guideline. This is something similar to the general comments of the UN in interpreting and elaborating the existing international human rights norm and also national laws on human rights. On the issue of freedom of expression, human rights defenders, on the issue of freedom of assembly, on the issue of land and natural resources, indigenous people, and many other guidelines. So this kind of work also were done by Komnas HAM in order to complement how we deal with actual cases against freedom of expression and human rights defenders online. Therefore, to conclude my presentation, since I know my rights only 10 to 15 minutes, at least there are strategic ways need to be considered by national human rights institutions in the increasingly human rights challenges in digital space. First, of course, as NHRIs, we need to continue assisting individuals groups, including human rights defenders who face threats, especially those vulnerable groups such as women, children, persons with disability, who may face bigger threats in the online or digital space. NHRI should continue to monitor policy and make recommendation concerning this digital space as such that Komnas HAM do with the Internet and Electronic Transaction Law and also the laws on protection of data privacy. National human rights institutions also need to cooperate with private sectors, technology companies, social media companies in ensuring that corporations also put a good human rights standard in developing their technologies, applications, and products. And of course, last but not least, among the SEANF members, it will be a great opportunity to share best practices on how national human rights institutions in other countries address similar situation on the advancing digital technology to human rights, especially human rights defenders. Thank you, Mr. Chair.
Thank you, Commissioner Adnike. I think you just take 5 minutes. It's a bonus for me. So just brief on the presentation of Dr. Adnike. One of the important things is the gap of the literacy and the governance, so the digital gap. So we, in various forum discussion that I have participated, all come to conclusion that the velocity, the speed, the development is very fast, but the governance is still behind this digital. So I think we are in this. This is important because when the governance is lagging behind, it emerges people that will blame not the absence of the governance, but people will blame the democracy. People will blame the freedom because it's too free, it's too much freedom. So that's something happens. So I think I will leave this to the audience to note and then prepare your comments and also questions after the presentation. Now we come to our second speaker. Take your time, Commissioner.
Assalamualaikum and good morning, everyone. It is always a privilege, an honor to be given this opportunity, this avenue to re-echo the voices of our rights holders in the Philippines, because the presentation that I'll be making today is actually a report that was done by the Commission on Human Rights of the Philippines. It was a research in 2024 on threats to digital rights of human rights defenders. So allow me to share with you the report. There are particular cases, specific cases that we looked into. Of course, the situation of our human rights defenders in terms of the freedom of expression, freedom of speech, and of course, we also have our recommendations in the presentation later. If I may, onto the next slide, please. So that is the outline of the presentation, as you can see on the screen. This is the guidance given to us, of course, by the organizers of this particular panel. And the CHRP study, as I've said, the research focused on 3 digital threats encountered by the human rights defenders in the Philippines. First, restrictive legal and regulatory frameworks that are used to arbitrarily and indiscriminately associate HRDs with left-leaning groups. Second, the blocking or banning of media outlets and official civil society organization websites, which disrupts communication and access to information. And third, information operations employing cyber troops, both human and automated bots, which unfairly manipulate and distort public opinion. So on to the next slide. Thank you. So allow me to provide two definitions for context. The General Assembly Resolution 114, ARES 53114 rather, on the Declaration on the Right and Responsibility of Individuals, Groups, or Organs of Society to promote and protect universally recognized human rights and fundamental freedoms, or simply Declaration on Human Rights Defenders, identifies or defines human rights defenders as individuals or groups who act to promote, protect, or strive for the protection and realization of human rights and fundamental freedoms through peaceful means. Now, onto the definition of freedom of expression in the next slide. It is, of course, a fundamental human right protected by the UDHR, the ICCPR, and it includes the right to hold opinions without interference, to seek information, to receive information, and to impart information and ideas through any media, regardless of frontiers, including, of course, the digital space, sometimes they call it the digital environment, or the cyberspace. The UN discussions emphasizes that digital technologies create new opportunities for realization, while also presenting new risks that must be managed through rights-respecting governance. HRDs experience threats to their freedom of expression through digital security risks in the form of online surveillance, censorship, harassment, doxing, red tagging, disinformation, and the indiscriminate or arbitrary use or weaponization of the law by the state or its agents. In the next slide, on empowering human rights defenders, in the age of digitalization, digital rights are an extension of human rights. Emerging technologies have furthered the cause of human rights defenders by promoting and protecting human rights, empowering individuals, and holding the government accountable for its actions through, one, mobilization and digital activism. This is where the digital platforms expand reach and enable rapid organization of campaigns, protests, and advocacy initiatives. Recent CHRP research notes that digital technologies empower HRDs to promote and safeguard rights, enabling broader participation and more efficient coordination of action. Data from civil society also indicates that young human rights defenders increasingly rely on online spaces for mobilization, despite rising threats underscoring the central role of social media, messaging applications, and online networks in sustaining activism. Second, documentation of rights abuses. Digital spaces allow real-time recording and reporting of violations abuses. HRDs can publish investigations, share evidence, and maintain digital records that support advocacy and accountability efforts. And third, accountability and evidence for advocacy. Digital records, open source investigations, and widespread dissemination of information create evidence that civil society can leverage in both national and international fora. CHRP research highlights the internet as an essential medium for documenting violations and encouraging authorities to act in accordance with human rights standards. In the next slide, allow me to present the threats and challenges to freedom of speech. While the digital space offers innovative ways to advance and exercise human rights, they also have the potential to infringe upon and suppress these rights. We commonly hear this as the double-edged sword of digital technology. And of course, the threats, of course, one would be restrictive legal framework. That would be in the next slide, please. Restrictive legal regulatory frameworks refers to laws that include provisions in criminal codes and other pieces of legislation related to defamation, insults, or blasphemy, and grant government authorities broad powers to restrict freedom online. In the Philippines, we have RA 10175, or the Cybercrime Prevention Act of 2012. It is an act defining cybercrime, providing for the prevention, investigation, suppression, and imposition of penalties, and for other purposes. Section 5 of this Act defines cyber libel as the unlawful or prohibited acts of libel as defined in Article 355 of our revised Penal Code, as amended, committed through a computer system or any other similar means which may be devised in the future. This law, while of course it aims to curb and eliminate crimes, but however, it has been used against journalists and HRDs. As many of you might be aware, our Nobel Peace Prize laureate Maria Ressa and her Rappler colleagues have since 2017 been subjected to a sustained campaign of legal actions and online harassment. In total, 23 cases have been filed against them. Ressa and former Rappler researcher Rinaldo Santos Jr. continue to face up to 6 years and 9 months in prison following a 2020 cyber libel conviction, which is currently pending final appeal before the Philippine Supreme Court. They were found guilty of violating the Act, and they were the first journalists in the Philippines to be convicted under the law. On to the next challenge, it's the restrictive legal frameworks on Anti-Terrorism Act. We have, wherein the CHRP, the CSOs, even the human rights defenders and the international community have repeatedly expressed concerns and criticism regarding this particular act, or the ATA 11479, particularly its potential to impact on civil liberties and human rights. We argue that the law's provisions could be used to suppress freedom of speech and association, despite an express inclusion for advocacy, protest, and other civil and political rights in the law itself. The CHRP's position is based on concerns that broad definition of terrorism and the expanded powers of law enforcement could lead to an erosion of fundamental human rights. As an example, we have Dr. Nati Castro. He is an emblematic case. This is one particular case wherein we have the Anti-Terrorism Council designating the physician Dr. Natividad Nati Castro as a terrorist. He was declared to be a terrorist in a release resolution dated December 7 back in 2020. The Council asserted that information, sworn statements, and other evidence collected by law enforcement and security agencies established Castro that he violated the Anti-Terrorism Act. He was even arrested in February 2022 on kidnapping and serious illegal detention charges, which the court later dismissed a month afterward, leading to her release. The CHRP expressed to the government our grave concerns on the situation of Dr. Nati. On the disruption of communications occurs through the blocking or banning of independent media outlets and CSO websites. For instance, the NTC, or the National Telecommunications Commission, blocked access to activist websites including Bulatlat, Pinoy Weekly, and the Monthly Review, falsely claiming they were affiliated with terrorist organizations without legal basis or mention in Anti-Terror Council resolutions back in 2022. On information operations as a challenge, information operations employ cyber troops, both human trolls and automated bots, to manipulate public opinion and disseminate government propaganda. Our research found that troll armies were paid between 30 to 100,000 pesos per month to spread disinformation, while public officials used verified online social media accounts to incite violence and target journalists, HRDs, and even members of the judiciary. Particularly, as an example, and this is all over the news, there is even a judicial court case on the particular two examples that I will be sharing. First, during the Sunshine Media Network International, famously known as SMNI program, a particular personality named Doreen Badoy Partosa labeled Rappler as a destroyer of the Philippines, and I quote that. Using her verified Facebook page and other official website, she was also branded the Rappler CEO and Nobel Prize winner Maria Ressa, an enemy of the state. In a separate post,
Badoy Pertosa uploaded insults against a member of our judiciary in the Philippines, Judge Marlo A. Magdosa Malagar, on her Facebook page, claiming that the judge is friends with the Communist Party of the Philippines, New People's Army, National Democratic Front, and that the judge weaponized a court of law to further inflict harm on a people that have long suffered the excess and inhumanities of the NCPP, NPA, NDF. Such posts garnered the comments and shares from her Facebook followers who openly supported her remarks. This prompted a group of lawyers to file before the Supreme Court of the Philippines a case of indirect contempt against Pertosa, and Pertosa was then found guilty of their indirect contempt for attacks against Judge Magdosa Malagar. Now, the role of the National Human Rights Institution, of course, at the national level, NHRIs must persist in implementing their mandates under the Paris Principle and in our respective jurisdiction, our respective enabling laws. For our recommendations, our research provided recommendations and calls out to the Philippine government, and please allow me to enumerate. Number one, to commit to a human rights defenders protection policy that reflects input from stakeholders and is endorsed by government agencies, and pass the HRD bill, which has been pending in our Congress. Number two, develop a comprehensive work plan to support HRDs against dignity security threats. Number three, develop risk assessment tools that are comprehensive, informed by stakeholder consultation, and updated regularly. Four, engage with stakeholders in advocacy and awareness-raising efforts. Number five, develop a systemic monitoring and reporting mechanism. And number six, amend regressive laws and policies that give broad powers for the interception of communication and surveillance, because these are open to abuse. Next slide, please. NHRIs, such as the CHRP, are actively involved in reporting to and engaging with international human rights mechanisms, including treaty bodies, the Universal Periodic Review, the special rapporteurs mandated by the HRC, and as NHRIs, we can call governments to task based on the concluding observation of the treaty bodies and the reports of the SRs. The findings of this international human rights mechanism often reflect the reports of NHRIs, CSOs, and HRDs working on the ground. For instance, the latest report of the Special Rapporteur on Freedom of Expression, Ms. Irene Can, when she visited the Philippines, we met with her and we gave her our inputs. And of course, this was incorporated. We are truly thankful that the findings and recommendations of the CHRP was incorporated or adopted in her report. And of course, a new treaty that can be leveraged to hold governments accountable regarding freedom of expression in the digital space is the UN Convention Against Cybercrime. In October 2025, the Philippines became one of the first countries to accede to the convention. Signed in Hanoi on October 25 to 26, 2025, the treaty facilitates cross-border sharing of electronic evidence and establishes 24/7 cooperation among states to address cyber-dependent and cyber-enabled offenses. Notably, it is the first international treaty to recognize the non-consensual distribution of intimate images as an offense, directly addressing concerns over online abuse. I hope I'm not over time, and thank you so much for your time. Mabuhay po.
Thank you, Commissioner. Thank you for finishing in your time limit. I think both presentations from Indonesia and from the Philippines reflect that the struggle to uphold these universal principles of democracy in the middle of this communication and digital revolution is and will be an endless effort, endless struggle. And this struggle not just merely imply commitment and courage, but sacrifice. So this is, I think, when refer to what happened with Reza, what happened to Fatia, and the other human rights defender. That was that reflects that this is our continuous and endless struggle to uphold this principle since the democracy was, started in 4th century before Christ with the death of Socrates. We still struggle for that. So now I think we still have 20-something minutes for Q&A. So I just provide time to, I think, two person to come up with comments or questions. If you want to clarify something, please. No question. Means that everyone is clear, means that the presentation was, well, okay.
Thank you.
Please.
Hi, good morning. My name is Marizen Santos.
Please help with the mic.
Hi, my name is Marizen Santos from the Commission on Human Rights of the Philippines. Basically, perhaps this is a question for all of us NHRIs, and it might not be an easy task for us as well on how do we counter information operations, influence operations, given that this is also funded by draconian member states that are they have vested interest to propagate misinformation, disinformation. So for us NHRIs, it's a challenge, but I would maybe like to pose a general question for both the commissioners on how, as CNF, we can contribute to defending, together with human rights defenders and other NHRs and civil society, against information operations.
I just want to keep that, if there's still some additional question. So no question. So now, please, who will be the first? Dr. Ratnike?
Thank you for the difficult task given to the NHRIs. In terms of resources, whether it is human resources, financial, and also technology resources, NHRIs are institutions which are usually very limited. But I think what is the strength of NHRIs is the value that we are campaigning for, the value that we share with public. The thing is, it is a big or a heavy burden for NHRIs like Komnas HAM or CHRP and others to inform public about digital literacy and its relationship with human rights. But I think with collaboration with civil society and also sharing of best practices among us, slowly but sure, I think there is a growing awareness about the possible threats in the use of digital technology among the people. But this is not a task that NHRIs can do all alone. We have to work with
civil society. And today in this conference, we are also inviting someone from Meta, that is the corporation of Instagram, Facebook, and so on. And also we need to continue working with the government to convince them that there should be a good governance of internet, digital technology, not good just in terms of protecting the interests of the governments, but good in terms of protecting human rights of the people. And this is an ongoing and continuous work that NHRIs must do. I think by having this kind of forum, at least we bring up this issue up to the region, that this is a concern shared by countries in Southeast Asia. This is not just a concern of the Philippines or Indonesia, but also others. I think that's what we can do as a regional forum, although it may not, one medicine that cure everything, but we have to do it anyway, and endurance is the key, as always, for NHRIs.
Thank you for the question, Ms. Marizen. I think the question of Ms. Marizen reflects the non-existence of the border in the digital environment. And it is very timely for me to manifest as an answer to the question that we can better do our mandate in one, as a region, as a Southeast Asian region, if we, of course, I will share the answer, the same answer that was given by Commissioner Atlique. If we share best practices, if we collaborate, and of course, if we support each other. We are very privileged that we have this avenue today to do just that, actually. So if we could probably have time later to discuss among ourselves on how we can move forward in this emerging issue in the digital space, then that would be something, of course, I'm sure that we will be able to bring back home to our respective jurisdictions so that we can effectively, more effectively rather, do our mandate as an NHRI. Thank you.
Thank you. Okay. Now, two hands there.
Thank you. Can I ask
From
question?
Commissioner for Myanmar,
From
please.
Myanmar. I am Dr. Tamien, a commissioner from Myanmar. I'd like to congratulate both of you. Your presentation is very interesting for me. And then you can protect those human rights defenders in your country for freedom of expression. But I agree that freedom of expression is very important for our human rights issues. But I would like to ask to you that, is there any ethics or code of conduct awareness raising for the human rights defenders? Because in Universal Declaration of Human Rights, Article 29 said that if you want to make your human rights things, issues or something like that, you should have to respect to others. So that is there, I would like to ask Indonesia and Philippines, is there an ethics awareness raising or code of conduct for those human rights defenders, do and don'ts for the freedom of expression in digital means? Thank you. Thank you very much.
Next question, Commissioner.
Thank you very much, moderator. My name is Prabianto, and I would like to express my sincere thanks to both ladies speakers. Very wonderful presentation. I have two questions for both of you. Number one is, how can human rights serve as a moral compass for the design, development, and deployment of the technologies, including artificial intelligence? And the second is, who should be primarily responsible for protecting human rights in the digital realm? Government, intergovernmental, or technology companies, or even individual users? Thank you very much.
Well, thank you. Two tough questions, I think. So the first, how human rights can become moral compass in this digital things. And the second, who should be responsible on this? The government or companies or so? Please.
Sir, thank you for that question. As to ethics awareness, one of the main wing or the functions that we do in the CHRP is our promotion mandate, wherein we go to the grassroots, to the communities, we engage with the government, with the CSOs, to raise awareness. And that includes raising awareness not only of the particular human rights of the right holders, but of course, parallel to that is that these rights are not absolute. There are limitations. Right to peaceably assemble, of course, in the Philippines, you can at any time do a rally, for example, or a protest, but that is with a permit if you are to use of, for example, a particular property, public property. So there's the balance, and we include this in our awareness raising, that while we have the absolute right to exercise the right that is innately granted to us, parallel to that would be the respect of the rights of others as well, and of course the observance of the rules and the regulations that balances a peaceful society. So these are the things that we do, we include in our awareness raising, in our promotion mandate. And I think allow me to answer the next question by the Honorable Chair. The question of who is mandated to promote, fulfill, protect the human rights in the digital environment, I think the digital environment or the digital space is just a new avenue. Whatever rights that we are, as rights holders, are able to exercise in the physical world, we can exercise in the digital world. Similarly, freedom of speech, freedom of expression. And because it is just a new avenue, that these are not new rights. These are rights that we enjoy in the physical world, but we have a new environment, new space, new avenue where we can enjoy the same rights. Therefore, just the same, the state, of course, as we all understand in the international community, the standard is the state has the primary duty to promote, fulfill, and protect the rights of its citizens. But it is not an absolute obligation that is only given to the state because of like I said, because of the non-border nature of the digital environment. The big tech companies has an obligation on their part, the same as the state, the same as you, as the user of the digital technology that is available to you. So I think it's an environment that requires everybody's cooperation, everybody's attention, so that the same peaceful society can be achieved in the digital space, similarly to the physical world that we all enjoy right now. Thank you.
I would like to answer the second question before the first one about who is responsible for the protection of human rights in terms of digital space. I think following the principles of human rights, the first to be responsible is of course the state, which means the government. But human rights is developing. We acknowledge that business sectors are also responsible in a way that they should be responsible. How then state and non-state actors can be responsible in terms of protecting human rights in the digital space? The state is responsible for formulating and producing regulation that ensure protection of human rights in digital space. We have internet law, we have international conventions, we have treaties and cooperation agreements among governments in order to protect human rights. But then, of course, the growing of policies is always slower than the challenges and problems. So that's the problem. And therefore, the role of corporations is not less important, because with awareness of the corporations towards their responsibility to human rights, corporations have the resources to develop a human rights friendly technology, which we can see from the application that we use. There is improvement in ensuring that our application can be less interference by others. We have non-encryption, that our photo cannot be, now WhatsApp cannot be captured, our status or profile photo, you cannot capture or screenshot the photo. So that is how corporation could also contribute in protecting human rights, of course without replacing the role of governments. And the third, of course, the role of people, the civil society organizations, communities, is again to build literacy on the safe digital space. I think this is where the homework is the most. From children to the elderly, we have to understand there is a risk, but there is an opportunity in using digital technology. And the first question about the ethics of human rights defenders, I don't know about others, but I think for Komnas HAM, in defining whether a person is a human rights defender, there are at least several indicators. First, what they do is a non-violent activities. If you commit violence in your advocacy, that is not a human rights defender. Second, you have to believe the universality of human rights. It means if human rights recognize every individual despite of their race, colors, genders, nations, and so on, you cannot select and choose. I want to defend my ethnicity but not others. I want to protect this religion but not others. I want to protect this gender but not others. It means you don't respect universality of human rights. And the third one, in determining whether someone can be issued a human rights defender certificate, of course, track records. This is probably similar with the principle of universality of human rights. You cannot tell others that you are human rights defender whenever you need to do, when it is of your interest. But when it is not of your interest, you say, no, I don't do that. That is not a human rights defender. And all over, of course, human rights defenders follow the principle of human rights in respecting every individual. So I think that's the ethics. When you say human rights, you don't select and choose.
Thank you. With that answer from the speaker, I think I will wrap up this session. So the human rights principles, democracy, it's universal. And we also must recognize that the threat against this implementation of this also universal. That's why the effort that we should make to tackle the obstacles should also be universal, not one by one. But I think SEANF and ASEAN also serve as a platform, a forum for us to also share our experience, how to tackle the issues, particularly on promoting freedom of expression. We should agree that freedom, the definition for freedom is freedom. We can't freedom unless or no less. The thing that we need to do, I think the commissioner, the question came out, is the literacy. And here we not just think about digital literacy, ethical literacy as well. For the political literacy, we need to also teach ourselves in this. And as a stand owner, I trust, I believe what the importance of our heart is. And as a human rights activist, I believe that the freedom of expression is very important when we talk about democracy. So to close this, to encourage friends, I think we say the expression is various, you know. We have polite way of expression, sarcastic way of expression, cynical way of expression, but this is the expression. And I will finish by citing the words of a big poet of Indonesia. I admire him very well, very much. The peacock, burung merak, Wes Rendra. A poem he wrote to an old man, old uncle, incarcerated in the prison and surrounded by thousands of mosquitoes. I will not go to the truth, all the verses, but some statement there that it's about the struggle. They say, kesadaran adalah matahari, kesabaran adalah bumi. Keberanian menjadi cakrawala, dan perjuangan adalah pelaksanaan kata-kata. In English, say that the conscience, the awareness is the sun. The patience or the resilience is the earth. The courage be the horizon. And the struggle is the implementation of the words. So we keep struggle to implement the words, the freedom, the values that we have committed universally, regionally, and also institutionally in our organization. With that, let's continue our struggle. In Timor-Leste, we used to say, a luta continua. The struggle continues. Thank you very much.
Thank you to Mr. Guterres and to all the speakers. You may now return to your seat. Ladies and gentlemen, we have now reached lunch break. Lunch will be served at the foyer in front of the ballroom, and for the musola is located on the second floor. We kindly request all delegates to return the meeting room before 12:30 p.m. to resume the afternoon session. Please enjoy your lunch. Thank you very much. and a Master of Science in Natural Resource Management from the University of Edinburgh. His expertise covers business and human rights, agrarian and land rights, corporate accountability, and environmental justice from 2017 to 2019. He served as National Coordinator or Focal Point on Business and Human Rights, BHR, Indonesia. And later, as Policy Consultant on Business and Human Rights for UNDP, Jakarta. So please, may I invite Vice Chair Prabianto Mukti Wibowo.
Good afternoon, honorable delegates, distinguished participants of SEANF Regional Conference, ladies and gentlemen. Welcome to the second sessions on practical application of the UNGPs to the activities of technology companies, including AI and data protections. I hope you all had a refreshing break and a good lunch. My name is Prabianto Mukti Wibowo, as was introduced by the MC. I am currently serve as a Vice Chairperson of Internal Affairs of Komnas HAM, and I will be serving as your moderator for today. After a busy morning and lunch, keeping the energy high in this afternoon is always a challenge. I appreciate your focus as we dive into this next insightful session. The topic we are discussing today is both timely and important. In this session, we will explore the implementation of the UN Guiding Principles on Business and Human Rights in the technology sectors by examining how technology companies integrate human rights due diligence into their operations, how states regulate and safeguard against potential human rights violations arising from their activities, especially on technology companies and digital platforms, and how national human rights institutions play a role in encouraging corporate respect for human rights while urging government to strengthen protection mechanisms within the information and communication technology sector. We have four speakers for this session who bring diverse expertise and background on their important topics. The speakers are Dr. Pichamon Yopantong, the UN Working Group on Business and Human Rights based in Bangkok, Ms. Nadila Rinaldi, a Public Policy Manager of Meta Indonesia, Ms. Prapai Ganjarniarin, the Chairperson of National Human Rights Commission of Thailand, and Mr. Upawin Sin, the Chairperson of Myanmar National Human Rights Commissions. So Mr. or Miss, actually, Miss Dr. Pichamon will be joining us through Zoom link. And the other three speakers are around with us in this room. And allow me now to invite the three speakers who are around to come to the stage. Ms. Nadila Rinaldi, Ms. Prapai, excuse me for misspell, and Mr. Upawin Sin. would you like to come to the seat, please? Ladies and gentlemen, in the interest of time and fairness, each speaker has been allocated a strict 15 minutes slot for their presentation, and I will be keeping a close edge on the clock and will give a gentle reminder when it exceeds the time limit. We will serve all questions for the general questions and answer at the end of all the presentation. So please make a note of your questions as we go along. Without further ado, I'm now inviting our first speaker, Dr. Pichamon Yopantong, who participates online via Zoom. Is he already in the Zoom? Okay. Dr. Pichamon Yopantong is currently the chairperson of UN Working Group on Business and Human Rights. She is also head of research and associate professor at the Center for Future Defense and National Security at the Deakin University. Dr. Pichamon currently leads the Responsible Business Lab and the Environmental Justice and Human Rights projects. As a political scientist, Dr. Pichamon teaches and publishes field-based research on business and human rights and the political economy of sustainable development in the Asia Pacific. She holds a PhD and Master of Arts from the Australian National University and a Bachelor from Thammasat University. Dr. Pichamon, the floor is yours.
And thank you very much to the organizers for inviting the UN Working Group on Business and Human Rights to join you today. I must apologize that I can't join you in person as I'm currently in Kuala Lumpur for the ASEAN ICT Forum here, which in fact focuses on the need for child rights to be embedded into business and human rights conversations, given that children are among the most active users of digital platforms and yet are also amongst the most at risk. These parallel gatherings in Jakarta and KL serve as a testament to this region's commitment to shaping a digital future that is innovative, inclusive, and rights-respecting. And so for the working group, it really is a great pleasure to be seeing these developments in the region. Many of you may already be aware of the working group and the work that we do, but for those who aren't so familiar with who we are, the working group of which I serve currently as the chairperson and the member from Asia Pacific states is comprised of 5 members, each representing different regions of the world. As independent experts who work as part of a fact-finding and monitoring mechanism of the UN Human Rights Council, we hold the mandate from states to promote, disseminate, and implement the UN guiding principles through activities such as undertaking country visits, delivering thematic reports, as well as convening the annual Forum on Business and Human Rights, which will take place next week, actually, in Geneva. Adopted unanimously back in 2011 by the Human Rights Council, the UN Guiding Principles on Business and Human Rights, or UNGPs for short, set out the duty of states to protect human rights, the responsibility of all businesses to respect human rights, and the need to ensure access to effective remedies. And so they are more than 10 years old now, and much has been accomplished during this time, but more has to be achieved as we embark upon this new decade, the second decade, I should say, of UNGP's implementation. The important thing to note here is that these principles are not optional. Rather, they are the global standard for responsible business conduct. For technology companies in particular, they provide a roadmap for navigating complex ethical terrain in artificial intelligence or AI, data protection, and digital innovation. Indeed, for companies operating in this sector, applying the guiding principles is not just about compliance, it is about building trust as well as longer-term sustainability. Companies that respect human rights not only reduce reputational and litigation risks to their operations, but they can also strengthen consumer confidence in their platforms, attract responsible investment, given that ESG criteria increasingly prioritize human rights, but also ensure continued access to global markets where ethical standards are becoming a decisive factor. In short, embedding the UNGPs is good business practice. On this topic of human rights, or the broader topic of human rights in the digital space and the role of businesses operating in this space, the working group delivered earlier this year a thematic report on AI procurement and deployment to the Human Rights Council, highlighting several key findings. Let me share some of them with you right now. Procurement, for instance, is a very important aspect of ensuring that technology companies abide by the guiding principles. Both governments and companies that procure AI systems, as opposed to developing them, still bear an obligation and a responsibility for ensuring that these systems respect human rights. And so in this regard, procurement contracts, acting as a form of leverage, should also embed human rights safeguards from the outset. The thematic report also acknowledged the importance of viewing business responsibility as a life cycle matter. Human rights due diligence must cover the entire life cycle of AI systems, design, procurement, deployment, monitoring, and decommissioning. And related to that, it is important for many of the AI systems that we see currently in place to become less than black boxes, for them to, for consumers and for rights holders more generally to be able to assess risks of bias, discrimination, privacy violations. That type of information sharing is absolutely necessary to ensuring that AI systems are made, in particular, are made even more accountable. And so from this perspective, the working group stressed in our report the need for transparency as well as explainability. The report also highlighted how when states deploy new technology like AI in areas such as policing, healthcare, or education, the risks to rights are magnified. And therefore, again, procurement processes, as well as deployment processes, must integrate human rights assessments in order to detect potential and actual adverse human rights impacts. And then finally, the working group's report also spotlighted how victims of harm caused by new technologies, including AI, often lack clear pathways to remedy. And so our report calls for stronger grievance mechanisms to be put in place, and also the importance for businesses as well as governments in this regard to collaborate with national human rights institutions. Altogether, the working group through our report was able to assess that too few technology companies are currently conducting meaningful human rights due diligence. And there is still a huge gap as well in understanding how new technology systems can disproportionately affect marginalized and at-risk stakeholder groups, including children and young people, making human rights due diligence in these contexts and in relation to these rights holders all the more urgent. Human rights due diligence, it goes without saying, is the backbone of the guiding principles. In abstract terms, the human rights due diligence process requires businesses to identify and assess human rights risks, including algorithmic bias, surveillance misuse, or data exploitation. It also requires businesses to prevent and mitigate adverse human rights impacts, including, as I said earlier, harms to children and to other at-risk groups. It is also about tracking effectiveness of responses and communicating transparently, in the case of businesses, to rights holders about those potential and actual adverse impacts. And then finally, as I said before, it is incredibly important for businesses to ensure that remedy is provided for, or that they cooperate in the provision of remedy when harm occurs. And again, the role of the state and the role of national human rights institutions in ensuring access to effective remedies is very pivotal. In light of all of this, the working group would like to stress here that human rights due diligence must be continuous and also embedded into corporate governance structures and not treated as just a one-off compliance exercise. The challenge before us is therefore clear. We need more technology companies to adopt human rights due diligence, and we also need them to do human rights due diligence rigorously. Here, national human rights institutions as well as regional mechanisms are indispensable. As the working group has noted in our other work on NHRIs, these institutions facilitate access to remedy for business-related human rights abuses. They can foster collaboration with both judicial and non-judicial mechanisms, and they also play an incredibly important role in protecting human rights defenders and civic space. And so in Southeast Asia in particular, NHRIs can serve as bridges between tech companies, governments, and affected rights holders, and in so doing, guide human rights due diligence processes, monitor corporate practices in this domain, and also amplify the voices of those who are marginalized and at risk. Strengthening the capacity of NHRIs, and I feel like I'm preaching to the choir here, is absolutely essential to embedding the guiding principles into local context and ensuring that these global principles translate into tangible protections on the ground. And so in concluding, I would like to encourage all of us today to remember that technology is not neutral in the sense that it reflects the values and safeguards or the lack thereof of those who design and deploy it. The guiding principles on business and human rights provide us with a compass to ensure that technology serves humanity rather than undermines it. And so embedding business and human rights considerations into the tech stack and along tech value chains, expanding human rights due diligence amongst tech companies, and empowering NHRIs in Southeast Asia to work on these issues are all exigent imperatives as global standards and national regulations are being negotiated and set in this sector. By doing so, we will not only advance human rights, but also build a digital economy that is resilient and inclusive. This is the future that we must strive for. And again, the guiding principles give us the roadmap to get there. And so I can only reiterate the working group's longstanding offer to NHRIs, to businesses, and to governments in the region that we are more than willing to provide support and assistance, especially assistance in relation to interpreting the guiding principles in order to ensure that tech companies abide by human rights due diligence and are, at the end of the day, rights respecting. Thank you very much, and I hand it back to the chair.
Thank you very much, Dr. Pichamon Yepantong, for your insightful presentation and for keeping to our time limit. So what we can take a note from her presentation was that the working group on business and human rights has already published a report. And in that report, we can learn that the importance of human rights due diligence has to be in place, as well as in providing the access to remedy for the company to promote in anticipating any harm from their operations, as well as we would like to thanks to Dr. Pichamon for offering the support for this group, as well as the government of Indonesia and the companies who involved in AI and digital technology. So once again, thank you very much, Dr. Pichamon. And now I would like to invite our second speaker, Ms. Nadila Rinaldi, or we usually name her as a Dea. Dea has an extensive background in the public policy dynamics realms through her diverse experiences across multiple sectors. At Meta in Indonesia, she is leading digital governance issues, including AI, commerce, and scams. Prior to Meta, she was at Indonesia's first B2B payment unicorn company, Sendit, and was part of the world-leading FMCG companies, Unilever and Danone. She holds a Master of Public Policy from the London School of Economics and Political Science, which was fully funded by the Chevening Scholarship Program. Time is yours.
Okay, maybe the operator can help presenting the slides, but good noon everyone. My name is Nadila Rinaldi, or you can call me Dea. Public Policy Manager at Meta. It's actually almost 1 year at Meta, and I'm honored to join you today at this SEANF conference to share our Meta approach to human rights, both as responsibility and as core part of our mission. And today I'll walk you through our policies, progress, and the real-world impact of our work and in Southeast Asia and also globally. Next slide, please. So at Meta, our commitment to human rights is not just a statement, and it's embedded in everything that we do. We align our policies with global standards, and we also have dedicated teams working across the company to ensure these principles are upheld. We conduct regular human rights due diligence, sharing our insights and action transparently in annual reports. When we identify impacts, we provide remedies and support, especially for those most at risk, such as human rights defenders. Our governance structure ensures oversight and accountability at the highest levels, with both policy and legal teams co-sponsoring our human rights programs. Next slide, please. Let me share with you where we stand today. So our code of conduct reflects our human rights commitments, and as a member of the Global Network Initiative, which I can share later on more, we're held to rigorous external standards, and since 2022, we've published annual human rights reports and conducted a company-wide salient risk assessment, the most important risk assessment, to identify and address our most pressing risks. We've also established our grievance and appeals process, including the creation of the oversight board, to ensure users have access to remedies. For human rights defenders, per se, we've strengthened our content policies and launched protective features, while our governance model ensures ongoing oversight and collaboration between key teams. Next slide, please. So our dedicated human rights policy team is at the heart of these efforts. This team works across Meta, identifying and prioritizing risks, whether they relate to specific countries, groups, or rights. And they help prevent or mitigate these risks through due diligence and product counseling, always guided by international human rights standards, including United Nations Guiding Principles on Business and Human Rights. The team also supports human rights defenders, engage with stakeholders at all levels, and provide expert advice to the oversight board on issues like transitional justice and remedy mechanisms. Next slide, please. In our most recent annual report, we highlighted several key initiatives. We completed an enterprise-wide salient risk assessment and provided updates on our work in countries like the Philippines, Palestine, Israel, and India. We also spotlighted urgent issues such as the Russia-Ukraine conflict and the situation in Iran, and shared our approach to the elections in the US, Brazil, and Kenya. And these reports are not just about transparency, they're about learning, adapting, and holding ourselves accountable. Next slide. Supporting human rights defenders is top priority for us. We've established specialized channels to address the highest security risks and created a global fund that has provided emergency support to over 4,000 defenders in the past 3 years. Our security initiatives now include advanced protection, which we've expanded to more countries and platforms, including Instagram. We also offer features like comment controls to help protect against harassment. Beyond technology, we partner with organizations like Access Now and the UN Special Rapporteur to strengthen the broader ecosystem. Importantly, we've updated our policies to offer stronger protections against gender-based harassment and to recognize journalists and human rights defenders as involuntary public figures, affording them greater safeguards. Next slide. Next slide. Our approach to content moderation is grounded in a single global set of community standards. However, we always respect local law, which are publicly available in our Transparency Center. These standards are built on our core values: voice, privacy, safety, authenticity, and dignity. And we follow a rigorous 4-phase process to develop and update these policies. Next slides, please. Next slide. Ensuring they remain relevant and effective in a rapidly changing world. Our standards cover a wide range of issues from violence and hate speech to misinformation and bullying, always with the goal of protecting people's rights and safety. Next slide. Our community standards address a broad spectrum of issues, and we have policies on violence and criminal behavior, safety concerns like suicide and self-injury, integrity and authenticity, and offensive content. We also address account integrity, hate speech, identity representation, spam, sexual exploitation, bullying, cybersecurity, misinformation, and more. And this comprehensive approach helps us tackle the many ways harm can manifest online. Next slide. Enforcement is a shared responsibility, and anyone can report content they believe violates our standards. And we review most reports within 24 hours. And that's why we are located globally, and our global safety and security team includes over 40,000 people with more than 15,000 dedicated content reviewers. Artificial intelligence helps us to proactively detect and prioritize harmful content for review. Our standard process ensures that every report is routed, reviewed, and responded to, closing the loop with the person who reported it. Next slide. And let me walk you through our reporting flow. And anyone can report content, and I will not be tired reminding everyone for you to report if you find content that violates our community standards. With the help of AI, reports are reviewed against our community standards or routed to a reviewer with language expertise, including in Southeast Asia. And our reviewers then assess the content and take appropriate action. And finally, we close the loop by informing the reporter of the outcome, ensuring transparency and accountability. Next slide. Next slide. Next slide. So when we receive government requests to restrict content, we follow a strict assessment process, and we evaluate the legality, legitimacy, necessity, and proportionality of each request. Always considering our human rights commitment, if a request is overbroad or risks harming freedom of expression, we seek to minimize its impact, sometimes by offering appeals and sharing information about the request externally. Our goal is to be as transparent and as accountable as possible. Next slide. The life cycle of a government request starts with the incoming request. We first check if the content violates our community standards. If not, we conduct a legal review to ensure the request is procedurally valid. And we then assess the request against a 5-part human right test: legality, legitimacy, necessity, proportionality, and external risk, as you can see here. Only after this thorough review do we decide on the appropriate response, which may include mitigation measures on external transparency. And our due diligence assessment is rigorous. We ensure that any government request to restrict content meets international human rights standard and our own commitment as a GNI, Global Network Initiative member. We look at the law, the purpose of the request, its necessity in a democratic society, and whether it is the least restrictive means available. This process helps us protect user rights while complying with legal obligations. Next slide, please. Now I'm going to move on to transparency and accountability. So Meta's membership in the Global Network Initiative is a cornerstone of our human rights commitments. The GNI brings together companies, investors, academics, and civil society to uphold freedom of expression and privacy online. As a board member, Meta is independently assessed every 3 years on our implementation of GNI principles. We require governments to follow due process, keep detailed records of requests, and interpret demands as narrowly as possible to protect users' rights. Under GNI guidelines, we require governments to follow established legal process. Next slide, please. When seeking to restrict freedom of expression or access personal information, We request clear written communications explaining the legal basis for any demand, keep records of all requests, and interpret them as narrowly as possible to minimize negative effects on freedom of expression and privacy. This approach ensures that we uphold our human rights commitments even in challenging situations. Next slide. Our Transparency Center is where we share detailed information about government requests and content restrictions, including in Indonesia and Southeast Asia. When we restrict content based on local law, we notify users and in most cases inform them which government authority made the request. This commitment to transparency helps build trust and ensures users understand why their content was affected. Next slide. In Indonesia itself, Indonesia is featured in our content restrictions report with updates for both the first and second halves of 2024. We provide detailed data on the number and nature of the government requests, our responses, and the impact on users. This transparency is essential for accountability and for fostering dialogue with stakeholders in Indonesia and also cross-region. If you see this number, it's quite high, but then again, there's also like a specific content that we proactively always do, and it's related to gambling. Next slide. And we are committed to enhancing transparency for users whenever we restrict content based on a government report that it violates local law. We inform the user. In most cases, we also tell them which government authority made the request, and this empowers user with the information and helps them understand the context of our actions. And as you can see here, we provide them the reason why the content is taken down too. Next slide. Okay, I think that's it. So Meta's approach to human rights is comprehensive, transparent, and always evolving, of course. I think we are working with a lot of experts to improve our policy and also our approach. And we are committed to learning from our experiences, engaging with stakeholders like SEANF, and working together to strengthen human rights protection across Southeast Asia and beyond. Thank you, and I look forward to your questions and insights.
Thank you, Dea, for your interesting presentation. And one thing that was come up to my mind, and I'm a bit confused that I thought that Meta is a manufacturer company, but now I learned that Meta is some kind of platform, technology platform for communications. So I take note of your presentation that the Meta commitments in respecting human rights is very strong and very clear, and I hope that it will be, applied to other companies following the Meta guidelines. So the next speakers, I would like to invite Ms. Porn Prapai Ganjanarit. She has been the chairperson of the National Human Rights Commission of Thailand since 2021. Prior to that, she has a distinguished career in diplomacy and international affairs, having served as Thailand's ambassador to the Netherlands and held key roles within the Ministry of Foreign Affairs. She holds a master's degree in public administration from the National Institute of Development Administration and a bachelor's degree in economics from Thammasat University. So time is yours. Please.
Thank you so much, and good afternoon again to my dear friends and colleagues. Yeah. First of all, thank you for the opportunity for me to be able to share with you today on the experience of NHRCT on how the UNGPs can guide technology companies in practice. As you are aware, Southeast Asia is seeing fast growth in the global digital economy. The region now has, I think, more than 460 million internet users, accounting for around 80% of the population. New technologies such as AI and cloud systems are becoming part of every sector business, government, and public services. But while these technologies create major economic opportunities, of course, they also bring risk of human rights violations, including those related to privacy, equality, and inappropriate surveillance. As Khun Ditchamon said earlier, at the global level, we have this UNGP, which set out the state's duty to protect the responsibility of businesses to respect human rights and the rights of affected people to access remedies. In Thailand, we have also, apart from UNGP, we have National Action Plan on Business and Human Rights, or we call it NAP, and enacted laws that help protect human rights in the online space, such as the Personal Data Protection Act, or PDPA, and Computer-Related Offences Act. But however, we continue to see human rights violations in the digital space, as you are all aware. These include online child exploitation, using children to create inappropriate content, hate speech, and online scams. These issues show that existing mechanisms and laws are still not enough. Businesses, especially those providing technology services, must take a proactive role in respecting human rights and putting the UNGPs into practice in a concrete way. This is essential to maintaining a balance between promoting innovation and protecting human rights and human dignity. Let me just share with you a bit about the NHRC's work in handling relevant complaints with regard to digital sector. Though we have international principles and domestic laws that regulate business conduct, cases of technology-related human rights violation do occur quite often, actually. In 2024 to 2025, 2 years, we have received quite a number of complaints. We have issued recommendations on cases which are mostly affecting privacy, freedom of expression, and children's rights. I'll give you 3 examples of our action in such cases. The first one is about the complaints that we received about Thai people who were told through social media that they would get good jobs with high pay at a Chinese company in Lao Cai and in the Gogang area of Myanmar, because it's through social media. After they arrived, of course, their phones were taken, they were locked up, harmed and forced to work, calling mostly, and then working. The NHRCT sent an urgent letter to the Prime Minister and worked with all concerned agencies to assist them. We joined the rescue planning, monitor the screening process, and help contact their families. These efforts brought everyone back to Thailand safely and into the protection and support system. I think you are all aware of this kind of cases, because this is one of so many cases that happen not only Thailand but around the world. Not only those Thai people, but also people from various regions, even from Africa, from the Latin America and neighboring countries. From time to time, we receive complaints that they are all locked up in the areas in the neighboring countries, forced to work. They were there through all these social media connection. This is one of the complaints and example that we receive as a result of this social media and, of course, digital technology. The second one is about the border conflicts between Thailand and neighboring countries. Of course, with all these conflicts, of course, we call on, we have a statement to call on people concerned to end violence and incitement, because with all these conflicts, of course, there have been communication through social media inciting to hatred from both sides, resulting even more border conflict. And of course, we issue a statement on this issue. And the second one is just last month that we encourage the public to respect different views and avoid using harsh or aggressive words and intimidation online after a rise of even more border-related hate speech. These events show that human rights issues now arise both offline and online, and remind all sectors, including tech companies, of their shared role in keeping digital platforms free from hate and division. The third example that we would like to just share with you is about the cases that we investigated where children were shown in online content without their consent or without hiding their identity. We found that when parents, guardians, or teachers use children in online content, it may violate their privacy and personal data and can affect their mental health and development in the long run. The NHRCT recommended that the Ministry of Education and other agencies set clear policies, use official school accounts for posting content, and provide training on children's rights and digital skills so that the online environment puts the best interests of the child first. In all three cases, the NHRCT recommendations highlight both the government's duty to protect and the responsibility of the business sector to respect human rights, especially companies that operate online platforms. On our road to promote human rights in the digital and AI era, for NHRCT, we have made human rights and artificial intelligence, or AI, a key priority for the 2025 Human Rights Assembly, which will be held in December later this year. The aim is to promote responsible use of technology across the public and private sectors. As part of this work, we organize workshops in different regions in the country, North, Northeast, South, and in Bangkok, with government agencies, civil society, academia, and the private sector. All concerns, all attended about AI impact on privacy. I mean, those participants reflect their concern on AI's impact on privacy, safety, freedom of expression, and children's rights. They also pointed to other issues such as the risk of people losing jobs, gaps in access to technology, people depending too much on AI, and the fast spread of false information. These inputs will be developed to some kind of resolution and recommendation so that we can send it to the government to set clear AI rules, because of course right now it's still not clear yet how they will go or deal with all these problems. And we hope that we are able to promote responsible use, improve public understanding, and ensure that all sectors can take part in shaping national AI policies. We also had a meeting with a big tech company. I wouldn't name the name of the company, but a real big tech company in Thailand, to discuss about what such company can do to fulfill their responsibility in developing AI in developing AI. And from the discussion, we find that human rights can be built into technology in a practical and systematic way based on such principles as safety, privacy, inclusiveness, transparency, and accountability. Such principles should be applied from the product design stage to ensure that all technologies respect human dignity and reduce risk to users' rights. We are encouraged to learn that efforts are being made to assess the human rights impact of technology on users. This reflects that such companies are taking steps in line with the human rights due diligence advocated in the UNGPs. We hope that such initiative would lead to the development of effective measures to prevent or reduce potential harm from the use of technology. The company that we visited also developed such guidelines and tools for managing harmful online materials. There are clear safeguards to prevent dangerous content, especially any form of child exploitation, along with tools that help parents monitor their children's online activity while respecting children's right to information. As regards to harms caused by errors or biased information generated by AI, there are ways to protect individuals from such harm. Technically, labels can be added to show when content is created by AI. This can be done in cooperation with content producers. However, these collaborations remain voluntary at this stage. We will comply all these good practices that we have learned, and hopefully we will develop a recommendation to be discussed and then to sort of forward to agencies concerned so that they can just maybe create some kind of more friendly and then safe environment for those who are engaged in this digital technology. So as AI expands, companies should ensure AI transparency so users know whether content is created by AI or by a real person, so that it will help reduce misinformation. These practices should apply to both large companies and SMEs. As respect for human rights is a shared responsibility, we will work with all these people, including the Electronic Transaction Development Agency, or EDDA, which is under the Ministry of Digital Economy, to sort of develop Thailand's AI governance framework to ensure that human rights principles are fully considered. We also believe that AI developers should conduct human rights risk assessments in line with the UNGPs and human rights due diligence. In the long term, the NHRC will support a balanced legal framework that protects people's rights while still encouraging innovation and economic activities. At this regional level, the key question is not how fast technology advances, but how we ensure that such progress respects human dignity. Turning the UNGPs and AI governance frameworks into real practice requires strong cooperation from all sectors. AI is new and developing quickly, and many of its human rights impact are not yet clear. So sharing experience on AI and governance is therefore useful for our country. CNF can be a platform for learning, exchanging good practices, and setting a common direction for human rights protection so that technology in our region grows in a responsible way. Thank you. Almost done. Thank you.
Thank you very much. Thank you very much, Madam, for your presentation. And I think all of us here was listening and learned very much from her presentation. It was quite interesting in sharing the Thailand's experiences in advancing the AI technology while respecting the human rights. So it was very insightful presentation anyway. So, as for the last speaker, I would like to invite Mr. Paul Lin Sin. He is the chairperson of the Myanmar National Human Rights Commission, appointed under the 2025 reconstitutions of the commissions. He has played a leading role in numerous human rights initiatives, including legal awareness seminars to promote the rule of law. He has also advocated for human rights protections in the field of digital age, participating in international conferences about digital transformation and governance. Mrs. Paul, the floor is yours. Please, please. Your pleasure, sir.
Good afternoon, colleagues, ladies and gentlemen. It is my honor and pleasure to be here with you, particularly at the annual conference of SEANF. Indeed, I'm not that very expert in business. Actually, I have been serving in the government service and public service together for over 47 years, but I'm not that expert in business. Anyway, this is really very important topic, very sophisticated, and of course, very broad. We also learned a lot from our previous speakers. It's very informative, and I would share our point of view and our experience. Ladies and gentlemen, it is indeed the 21st century has been defined a continuous and accelerating technological revolution, particularly with the recent advancement of artificial intelligence, AI. It serves as a powerful demonstration to this trend. The key aspect of this revolution include, number one is rapid innovation. The trace which new technology emerge and become integrated into daily life and is unprecedented. This encompasses everything from smartphone to internet to biotechnology and quantum computing. Then second point is also the connectivity. Global interconnectedness has fundamentally changed. Of course, look at the data dominance. The ability to collect, process, and analyze data, driving decision-making process across the industries, businesses, science, and government. Of course, AI acceleration is incredible. It has led to every sector. AI is transforming many sectors, almost every sectors, I would say, like healthcare, science, transport, shaping the manufacturing, logistic, science industry, etc. These interconnectedness technologies are fundamentally changing how we live, how we work, how we interact with this world. So it is strong evidence that this is the age of technology revolution. That is why the United Nations General Assembly recognized the rapid advancement in information and communication technology as a driving force in accelerating progress towards development in various sectors, which is important to achieve these sustainable development goals. So they are also noted that the increasing of the digital technology has impact on the enjoyment of a wide range of human rights. And they even recognize that the digital technology can work enablers of human rights, but they notice that without appropriate safeguard, it may seriously threaten the protection of full enjoyment of human rights. So originally, next slide, please, before, previous one, sorry. Originally, the human rights standards were seen as responsible only for governments, not for the private sector. But times have already changed. With the globalization and digital transformation, technology companies and business enterprises play a very major role in respecting and protecting human rights. Therefore, the United Nations took a leading role to form UNGPs. So the main platform was, I think, yes, UNGC, 10 principles. Actually, UNGP, as I learned, is introduced by the former Secretary General of the United Nations, Kofi Annan, at the World Economic Forum. So those 10 principles encourages companies to adopt sustainable, socially responsible policies based on 10 principles. The 4 sectors, they focus on human rights, labor, environment, and anti-corruption. In 2011, the next year, the United Nations Guiding Principle on Business and Human Rights, UNGBs, were unanimously endorsed by the Human Rights Council Resolution 17.4 in 2011. Those UNGBs set out the protect, respect, and remedy framework, which states that the government must protect, businesses must respect, and both must ensure access to remedy for human rights violations. And the UN Guiding Principle on Business and Human Rights provide precisely the guidance, a universal framework built on 3 interrelated pillars: state duty to protect human rights, and cooperate responsibility to respect human rights, and the right to access remedy for victims. So next 13 years, the UN General Assembly Resolution 78/267, it says, seizing the opportunity of safe, secure, and trustworthy official intelligence system for sustainable development, and it affirms that human rights and fundamental freedom must be respected, protected, and promoted through the AI life cycle. Another UN Human Rights Council Resolution 55/22 on human rights defender and new and emerging digital technologies. It emphasizes that states and companies must refrain from using AI in ways that threaten the privacy, equality, and freedom of expression, and ensure protection of human defenders from technology-related risk. Those resolutions actually highlight that AI governance must align with the UNGPs. And UN also called for bridging the global digital AI divides, ensuring that technology progress supports sustainable development and benefit all societies. So, next slide. So, we should focus on the practical application of these principles in the technological sector. Number one, how do technology companies implement UN GPs particularly through human rights due diligence? Number two, how do states regulate and safeguard against potential human rights violation? Number three, how do national human rights institutions and NHRI play their role in encouraging companies and advising government to protect human rights in the ICT sectors? Next slide. Next. Thank you. Today, in the digital era, we face new challenges. The rise of artificial intelligence, data analytic, and surveillance system has brought great innovation, but also serious ethical dilemmas. It is for sure that these technologies can threaten privacy, equality, and freedom of expression if they are misused. AI developers must secure non-discrimination, transparency, accountability, and algorithmic systems. So data-driven businesses must comply with the data protection principles and avoid misuse of personal information. The technology is not just a tool, and it is a force that shapes the society. Next slide, please. So companies must balance innovation with ethics, and respecting human rights should not be an option. It should be a core part of how technology is designed, developed, and used. So IT companies should conduct human rights due diligence. And technological companies should uphold the UNGPs by embedding human rights due diligence into every stage of their businesses. Next slide, please. So another question that is the government role. Governments play a vital role in safeguarding human rights in the digital area by creating strong legal frameworks, monitoring compliance, and enforcing accountability. The law should be aligned with the global standards, ensuring privacy, transparency, and fairness. Independent monitoring system and effective enforcement mechanism are key elements to formulate. Next slide, please. So many countries are now integrating the UNGPs into national laws and the regulations regarding AI. The European Union, I don't want to go in detail, the European Union and the United States and some other Asian countries are also following those UNGPs. In Asia, like Japan, South Korea, and Thailand are also developing National Action Plans, NAP, on business and human rights. So promoting responsible data governance. And of course, the Danish Institute has also produced practical tools. Next slide, please. While we are talking about the UNGP, and we would like to appreciate the input of working group on UNGPs, and their inputs are really valuable and very important to become a strong UNGP. So relating on that, OACHR made a report at the 59th section of the Human Rights Council, which clarified the role and duty of states and responsibilities of the company when using AI and technology. The first pillar of the UNGP is state duty. It is to protect. Government and the obligation to ensure that human rights are respected by all actors within their jurisdiction, including private technology companies. And another question is the role of the NHRI. So NHRI occupy a unique and strategic position at the intersection of state and corporate pillars of the UNGB. They serve as independent bridge institutions linking the government, businesses, and civil society in promotion and protection of human rights in the digital age. So the role can be seen in two principal dimensions. One is encouraging and advising companies, and two is monitoring and advising governments. So, Excellency, ladies and gentlemen, next slide, yes. The practical application of the UN Guiding Principle on Business and Human Rights, UNGP, in the technology sector depends on the collaboration among all stakeholders. Companies must integrate human rights due diligence into their operation and culture, while states strengthen laws and enforcement to ensure accountability. National human rights institutions play a key role in monitoring, advocacy, and providing guidance. Civil society organizations help hold both governments and companies accountable and give advice to affected communities. In conclusion, the UN Guiding Principle on Business and Human Rights are not an abstract ideal. They are a practical and dynamic framework for navigating the human rights challenges of the 21st century digital economy. Thank you for your attention.
Thank you, Mr. Paul. You have used your time perfectly, 15 minutes. So your presentation was quite interesting in providing the comprehensive overview of the UNGPs in facing the digital era. And I fully subscribe that the AI, for example, is an enabler for a development, but it has to be accompanied by a good safeguard, yeah, to protect the human rights violation by the any sectors. So, ladies and gentlemen, we have already heard and learned from the 4 speakers, and thank you very much to all of our speakers for their excellent presentation. And as a token of our appreciation, please give them a big round of applause. And now I'm open question and answer. So I will invite the floor. If anyone would like to seek any clarification or put some question to our speakers here, please raise your hand. 1 here, and then second from Timor-Leste, and the third. Okay, we have 3 persons who are willing to put some question. First, I will invite the lady from, or the commissioners from the Philippines, please.
Hello. 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 Yes. Am I loud? Yeah. Yeah. Okay. Thank you, sir. My question would be addressed to Ms. Dea from Meta. Thank you for the presentation. As a user myself, it was very useful and helpful. My question would be: you've discussed and shared with us the mechanism for complaints, how it is being taken down, the process. My question now would be, is there a appeals mechanism? And how does the process go about? Since some posts or content that are taken down sometimes are, being protested by the account user or by the content owner. So maybe you could educate us more on the appeals mechanism on a particular content that is being taken down. Thank you.
Thank you, madam. So I think before it is answered by our speaker, I would let the second gentleman here to put his question.
Yes. One of my questions, I second Commissioner Faidas. So the question is to Ms. Dea. I'm raising my question representing a nation with 1.3 million population, which almost 1/3 or 1/4 of them is the Facebook or social media users. I just want to hear from Meta some explanation about mechanism of filtering, particularly on a country that the main language of the expression is still not recognized in the Google or in the social media. So the hate speech, disinformation, sometimes still occur in the Facebook platform without any intervention. So my question or my concern is how we deal with that situation when the main language of the expression is still not recognized, which limit the platform to identify that this expression is hate speech. So that's my question. Thank you.
Thank you. And now the third persons, please.
Thank you very much. Thank you very much. Can I ask question to Ms. Nahilda, please? Because I'm interested in your digital governance. I think you are an expert in digital governance, and you are working in Meta, so that in our country too, we have so many scam and fraud in digital area, like multimedia platforms such as Facebook and Telegram and so on. There are so many gambling advertisements, and so many people are making gambling. So that I would like to know about that. In your Indonesia, Meta can rip off those people. If you found those gambling website or something, can you take it out from the website or something? That is my first question. And if you can make it like that, we want to share the knowledge and the skill for my country, because of the Global Network Initiative is doing such kind of things for digital governance. Thank you very much.
Thank you, sir. So we have three questions, and mostly, or all even, addressed to Dea. But I hope the other speakers will also have any comments or any answer to those questions, as well as Dr. Pichamon. I recognize that she is still online. So can you hear clearly, Dr. Pichamon? Okay, good. So we would like also to hear from you to answering the questions. So please, Dea.
Yeah, thank you so much. And I'm super honored that all of the questions actually directed to us. So I really hope that I could answer it and provide more clarity. So I think the first question is related to appeals mechanism. And yes, we indeed have the appeal mechanism. And in fact, we work with the external independent party who are the experts in this area, called the Oversight Board. And so apart from, for example, we receive reports for example, from other users, and then we, let's say, mistakenly take it down, there's also the oversight board that actually have this process where you can actually appeal, and it can be conducted internally and also externally. So you as a user can also appeal, from external party. But apart from that, also in our applications, you can actually appeal to directly through your applications, where you can sort of like protest, quote unquote, appeal, like why this is taken down, for example. So yes, indeed. But in terms of the process itself, of course, because it requires like a different review, case by case basis. So it will depend, like depends on the complexity of the cases itself. So I hope that provides clarity. And then about Bapak from Timor-Leste, right? So I think about the filtering and the speech part. So we, as I mentioned, we basically develop our policy, and we basically develop it by considering the local law too. And under our community standards, we already have what is the hate speech, what is categorized as that, what is allowed and not allowed. And apart from that, we also invest in features, for example, like comment control. If, for example, when you see later a lot of hate speech or bullying or harassment, you can actually try to put the keywords and then block them, so that they're not, included in the comment section, top comment sections, because again, it's there's like a barrier in terms of a language, and we acknowledge that we're not like perfect, but then again, there is like a features for you to actually restrict that from being highlighted. Apart from that, again, our responsibility as a company is to provide strong user control. So that means that you can actually report that if you see that there are like keywords that probably insinuating like hate, and we really need that. When you see that, please report to us, and we will do our best to review it. And also like because we also have a lot of people working 24 hours with a very specific language, so we will make sure that we actually proceed and close that report. So I hope that answers your question. And then the last one about the scam, fraud, and gambling. Yes, we restrict, and in fact, our effectiveness to restrict is 98%. But you can imagine if, let's say, there are like 232 million contents, the rest 2% is still like 4 million contents. So our system is not perfect. But we do scale enforcement by using the keywords. For example, there's like a specific keywords that is relevant with scam or gambling, right? And so we try to do the scale enforcement. We implement that keywords, and then we try to block that. But again, what I want to say is that this scam and gambling, they're like a criminal syndicate. And it's very important not to focus only on the digital space. And so what we're trying to encourage is that how can we work together to focus too on the off-the-platform effort, and together with the law enforcement to actually really, combat and tackle these issues in more comprehensive manner rather than just focusing on online. That clarifies. Thanks.
Okay, thank you, Dea, for your answer. And I would like to give a time for other speakers.
Right.
To add on what Dea already explained.
Well, we appreciate your work on this, but of course it's a very challenging job, because I think those on the other side, they are so advanced in trying to just lure people into their business. So we just give you moral support. Maybe you have to do a bit much more to just try to keep up with our so-called scammer and whatever you call it, because as you are aware, I think it's around the world, we cannot just keep up with all the villains who are able to just maybe just get people into their business very easily. So just my moral support to the big tech company
to see how you can just cope with all these challenges. Yeah.
Okay, thank you. And Mr. Paul, you want to add on something?
Thank you. Thank you. Oh, talking about the online scamming, this is really a serious threat to our people, our country, and of course not only to us, but also to our region, particularly our neighboring countries. And of course, beyond that, it is also impacting to the whole world. That is why we are trying to abolish such a kind of threats to all people. Particularly, it's relating to the telecommunication and digital technology. That is why the ways we have to do is, as the matter already expressed that our friendliness and our cooperation, our negotiation are the best way to fight against such a kind of online scamming threat. So our cooperation, particularly our CNF, we are good practices there. We are sharing knowledges, sharing information, sharing ideas, and we also welcome our colleagues anytime for your input to fight such a threat to all human beings nowadays. Thank you.
Okay, thank you, Mr. Paul. And Dr. Pichamon, are you still online?
Yes, I still am.
Any comments or any inputs?
I would just say that there's a lot of, I think, goodwill in the room and in the sector more generally to ensure that human rights are not adversely impacted by the products, services, and activities of these tech companies. At the same time, we have to bear in mind that progress in this space in relation to the actual implementation of human rights due diligence processes by these companies is still lagging behind other sectors, but is also presenting a real risk in terms of allowing human rights abuses to go unnoticed. So it is incredibly important for the sector to realize the need to adopt the guiding principles and to really realize human rights due diligence as a process in their operations as well as along their tech value chains. Thank you.
Thank you, Dr. Pichamon. Ladies and gentlemen, I'm afraid that we have run out our time for further questions. So I would like to, not to make a conclusion, but given a short note from our discussion today, that the UNGPs move the conversation beyond ethical dilemmas to a clear framework of corporate responsibility and public policy expectations. For technology companies, this means that proactively managing human rights as a core business risk, a practice increasingly reinforced by a global movement toward mandatory human rights due diligence regulation. So, thank you very much for all our speakers, and we end up our session today. Thank you for your kind attention and participations. Please enjoy the rest of the event. The session is now adjourned. Thank you very much.
Thank you very much to all the speakers and Mr. Prabianto Mukti Wibowo. Ladies and gentlemen, we would now come to a short coffee break for about 30 minutes. Refreshments are available at the foyer. And please, kindly return to the ballroom by 14:13 p.m. as we will resume the session promptly. Thank you, and please enjoy your coffee break. To all distinguished ladies and gentlemen, we kindly ask you to all enter the ballroom and please take a seat, as our event will begin shortly. Thank you. To all respective colleagues, we hope you had a pleasant coffee break. And please take your seat as we continue with the next session. The third session is Human Rights Protection in Digital Space for Vulnerable Groups, will be led by Commissioner Beda Angeles Epres from CHRP. Commissioner Beda Epres has served as Commissioner of the Philippine CHR since 2022, with his term extending to 2029. He holds a law degree from Arellano University and was admitted to the bar in 1995 at CHR. Commissioner Epres is the focal commissioner for the rights of older persons, children, and youth. He has advocated strongly for international legal protection for older persons and works to combat ageism, promote social protection, and support youth and child rights, including through legislation aligned with international standards. So please, may I invite Commissioner Epres.
Thank you very much, Madam MC. A pleasant afternoon to everyone. Before we formally start, I would like to call on the panelists in the third session. Would like to call on Mr. Wahyudi Jafar, if you are around, sir. Yes, please, the stage. Also, would like to call on the Honorable Ombudsman from Timor-Leste, the Honorable Virgilio da Silva Gutierrez, sir. And last but not the least, Datuk Mariati Roberts from Suhaka, Malaysia, ma'am. Good afternoon. Please take seats. Thank you very much. Again, a pleasant afternoon. I am so honored and privileged to chair the third session on the topic Human Rights Protection in Digital Space. As I am joined by three distinguished speakers who are authorities in their respective fields. But before I formally introduce them, allow me to share with you the significance of today's discussion in the realm of the digital age. As the world around us becomes increasingly digital, the scope of our work as national human rights institution has expanded to include emerging threats and challenges to human rights defenders, right to privacy, freedom of expression, and the protection of the vulnerable groups in the digital environment. I think all of us here today will agree that technology and human rights are not separate areas. They are deeply interconnected. That is why we must deeply engage in understanding the intersection of technology with specific sectors, such as the rights of children, older persons, women, persons with disability, and human rights defenders. Based on our program, we are allotted 70 minutes for the presentation and the question and answer portions, and the presentation of our respected speakers will focus on the situations and forms of human rights violations faced by vulnerable groups in the digital age, the policies and of the state with respect to the regulations and safeguards against potential human rights violation, and of course, the role of national human rights institution in the protection and promotion of human rights in the vulnerable group. So without much further ado, I will now introduce our first speaker. Our first speaker is the Executive Director of Catalyst Policy Works. It is a public policy think tank focusing on digital governance and innovation. His work centers on policy and regulatory frameworks for emerging technologies such as artificial intelligence, with a strong focus on data privacy and AI governance. He was one of the key initiators behind Indonesia's personal data protection law. Over the past 15 years, our speaker has led studies and policy advocacies on data protection, internet governance, digital rights, and cybersecurity. He previously served as executive director of ELSAM and co-founded Raksha Initiatives, a nonprofit org focusing on strategic security and digital governance. He is currently a board member of ICJR and fellow at the Global Network Initiative and completed an executive program at the Lee Kuan Yew School of Public Policy. He holds a law degree from Gadjah Mada University and a Master's of Science from the University of Indonesia. Ladies and gentlemen, our first speaker, Mr. Wahyudi Jafar. The floor is yours, sir. We'd like to, whichever is convenient, sir. You want to take it here?
Yeah, thank you, moderators, for what is very distinguished introduction about me. Yeah. Good afternoon, ladies and gentlemen, distinguished participants of the conference of Southeast Asia National Human Rights Network. First of all, I would like to thanks to the Komnas HAM for inviting me to join the discussion in today. So for the elaborations about the challenges of the protection of digital rights, especially to the vulnerable groups in ASEAN countries, I will to elaborate the several points on the issue of the challenge, including the strategy and the rules of the NHRI to responding the challenge of the protection and the enjoyment of digital rights by the vulnerable groups. So for the first slide, please. Yeah, I will elaborate about the promising situation for ASEAN, refers to the several research regarding the transforming of the digital economy in ASEAN, especially after the COVID pandemic, because the COVID pandemic is a turning point of the accelerating of the process of the digital transformation in ASEAN. And currently, ASEAN reached around $300 billion on our estimate rise to $1 trillion by 2030 on the digital economic growth. And Indonesia leads the regions on digital economy with a value approximately 90 billion in 2024 and projected to rise until 360 billion by 2030, with the largest contribution from the e-commerce sector reaching until $150 billion. The last report released by Google Temasek in 2025 shows, the digital economy in ASEAN increased in total more until 7.4-fold on the global merchandise value, and jump in until 11.2 revenue since 2016, which all pave the way to the next phase in the region. So currently we're discussing about the impact of economic AI, artificial intelligence, as a reality in the regions. However, amid this opportunity and exponential economic growth, ASEAN faces various challenges in many aspects, particularly those related to the population of more than 680 million peoples in all of the regions with the 10 countries. Next, so what's the challenges in facing digitalization in ASEAN? So we are identifying the several aspects of the challenges in the facing of the digitalization in ASEAN in general landscapes, including the issue of a digital divide. It is also still most of the population does not have access to digital technology with disparities between urban and rural areas and between different income levels, including for the vulnerable groups for the several elements. Also, the issue of regulatory fragmentation, the absence of a unified regulatory framework for digital services creates barriers to cross-border digital trade and investment, and as each country has its own rules. For example, on the e-commerce sectors, ASEAN has of the ASEAN Agreement on Economic Commerce, but until now, each of the countries still try to improving the local or the domestic model for the accelerates of economic commerce, including in the issue of the response to artificial intelligence governance. Even ASEAN has of the ASEAN guides on the AI ethics and governance, but currently we have still lack of the response to the development of the AI technology here. Also, the issue of the data protection, for example, the several of the countries in ASEAN has of the data protection law, but with a different standard. The ASEAN tried to develop of ASEAN data management framework, but until now, the process of the ratification, the standard of the data transfer, for example, also still in the gap how to improving and strengthening the models of the standard of the data transfer. Also on the issue of the infrastructure and connectivity, the cybersecurity, including the issue of the online scamming. The last of the ASEAN's Ministry ICT meeting in Malacca on October 2025, the ASEAN's ministry recognized the new declaration, Malacca Declaration on the transnational crime, with a focus priority on the response of the online scamming increasing in ASEAN region. Also, we have the issue of the skill gaps, data management, including the financial literacy. We have in Indonesia, for example, the issue of the online gambling and the online peer-to-peer lending as an issue for the vulnerable groups, and we need of the the new and collaboration strategy how to respond of the online gambling, for example, between the ASEAN countries. Also, the issue of the online peer-to-peer lending. And what is the challenging for vulnerable groups? The next slide. We identify the four of the issue as a challenge for the vulnerable groups. The first one, still on the issue of the digital divide, fundamental challenge is persistent digital divides, which is evident across and within ASEAN member states. And the second one, lack of digital skills and literacy. Significant barrier is the widespread lack of digital skills and limited training opportunities, especially for vulnerable groups, including the elderly peoples. And the third one, specific of exclusion factors, some groups like for the peoples with disability, the elderly people, children, and the women in the rural area, especially the access of the digital economy. And the last one, the four, the policy and governance gaps. How is the inadequate policy intervention and regulatory frameworks often fail to meet the specific needs of vulnerable population. For example, the issue of the digital identity in Indonesia, in Philippines, including the issue of how the inclusivity to response of the development of the governance of artificial intelligence, also still debating about how to make sure the inclusion, the models of the development of the artificial intelligence in the regions. The next, it is the issue of the digital challenge in the level of the geographical isolation, including the affordability of the access for the vulnerable groups. Next, for the lack of digital skills and literacy challenge, so still as a barrier for the vulnerable groups here, how limited formal education providing the skills for the vulnerable groups, the age and generational gap, especially for the elderly adults, may have barriers such as limited digital literacy and how to use of the devices, including accessing the network. And also the issue of the labor mismatch, it is also as a factor how the issue of the scamming impacted to the trafficking in person in the regions. And the next challenges of the specific exclusion factors, including the issue of the constraints are particularly faced by indigenous community located in a remote area because they have not of the affordable access to use of the technology and the digital network in the region. And the next, for the issue of challenges of policy and governance gaps, because it is how the capitalism works. So still a market-based initiative in the processing and the formulation of the regulation. Also the fragmented regulation, as I mentioned previously. Also the issue of insufficient supports. How the models of the multi-stakeholders must be developed in the process of the developing regulation to response of the digital emergence. And the next, how to strategy for addressing challenges among vulnerable groups. We identify of the several strategy to response of the challenges, including enhancing digital access and infrastructure, how to tailor digital literacy and skills development, considering the situation and the need of the vulnerable groups, also fostering inclusive policy governance, how develop data-driven policies, how adopt a human rights-centered approach, how implementing the human rights approach as foundation in the process of the development of the policy regarding the technology, also regional cooperation and knowledge sharing between the ASEAN countries. And the next, the important role of NHRI in addressing of challenges of the digital landscape in ASEAN, especially regarding the vulnerable groups. I think the NHRIs, based on their mandate and the function, can develops the models of the monitoring and reporting about the violation in the enjoyment and the protection of the digital rights, especially regarding the vulnerable groups. Also policy and legislative advice, how the NHRI providing the policy recommendation to the policymakers during the process of the development of the policy regarding the technology. For example, in Indonesia currently, the government has the plan to develop national AI roadmap. So I think Komnas HAM also need to consider a develop of the several recommendation in the process of the developing of the AI national roadmap. Also complaint and handling and investigation regarding the violation of the digital rights. Facilitating multi-stakeholders dialogue, because it is the basis in the process of the development of the policy regarding the technology, use of the multi-stakeholder approach. Also promoting digital literacy and awareness, how integration and internalization of the human rights principles in the enjoyment of the digital access. And the last, capacity building, how NHRIs work to build their own internal expertise and capacity of civil society group to effectively respond the emerging digital rights challenges, including providing resource for digital security. And for examples, in the next slide, as a reference, how the good practice from another NHRI in the response of the emerging technology. For example, for the function of advising of policy and legislative measures, we reverse to the Equality and Human Rights Commission in Great Britain, how they are providing the policy recommendation in the process of the formulation of AI white paper, including the French National Consultative Commissions about the AI and securitizations. Also, the Danish Institute for Human Rights also set up of the external expert group on tech giants to respond to the democratic and fundamental rights issue. In the function of awareness raising, education outreach, we have the experience from the German Institute for Human Rights has raised awareness on digital rights, especially in the context of the use of AI, and how the Human Rights and Equality Institution in Turkey organized a capacity building workshop on the human rights impact assessment here in the development of technologies and AI system. I think it is work from Pak Prabianto in Komnas HAM, also how to develop the models of the human rights impact assessment, also human rights due diligence mechanism in the technological sector. Also handling the complaints, conducting investigation and strategic litigation. We have several reference and experience from the Ombudsman of the Republic of Croatia, how the conduct of the investigation on the allegation of the violation of the privacy by the taxi driver, online taxi driver in Croatia. Also, several AI-related cases have been brought before to the Netherlands Institute for Human Rights, and also monitoring and reporting on AI human rights. It is also part of the good practice from Danish Institute for Human Rights, the Albania People's Advocate and Support NHRI, also the Netherlands Institute for Human Rights, and the Scottish Human Rights Commission issued or released a paper on human rights and new technology in policing, how the policing conducted by the police institution must be follow the human rights principle or standard in the use of the new technology. And the last slide, it is the contributions of NHRIs in responding to the challenges of digitalization in the region. I think all of the members of SEANF can advocating for policies that ensure equitable access to the digital infrastructure and skills, particularly for vulnerable population and remote area in the region, in ASEAN. Encouraging greater business accountability and adoption of human rights due diligence by companies operating in the regions. We need to continuing the process of the discussion how implementing the UN guiding principle on business and human rights in the region with the several contextualization and also the considering of the local context. And the last, working with the regional mechanism like the ASEAN Intergovernmental Commission on Human Rights, ICHR, to embed human rights centered advocacy into ASEAN's work plan and framework, such as the ASEAN Digital Master Plan 2025 and the Digital Economy Framework Agreement, DIVA. DIVA still in the process of the consultation in the ASEAN government. So I think it is also opportunity for the NHRI to involve in the process of the negotiation and developing the recommendation in the framework of DIVA. So I think what is general overseas views about the challenges of the vulnerable groups in enjoyment and the protection of digital rights, how they are utilizing and optimizing of the digital technology in here, and what is the rules of the Komnas HAM to strengthening, to improving the enjoyment of the online rights by the vulnerable groups. Thank you, and over to you, Pak Moderator.
Thank you very much, Mr. Jafar. Thank you for highlighting that indeed COVID-19 has changed a lot in our way of life, and even, as you have mentioned, it has even accelerated the digitalization process in various sectors. But again, some of these processes may not be all positive, as we were able to identify challenges such as the digital divide, which greatly affects the vulnerable sectors of our society. There are also issues on regulation, cybersecurity, digital skills, and more importantly, the literacy challenge. And these challenges are supposed to be addressed by the government, being the and later on, we will be, after all of the presentation, we will summarize as to what or how should the National Human Rights Institution work so as to address the challenges that are identified by the speakers or by our National Human Rights Institution. So we now go to our second speaker. This morning he was a moderator, now he is a panelist. He is the current Ombudsman for Human Rights and Justice at the Proveedoria dos Direitos Humanos y Justicia of Timor-Leste, serving a 5-year term from 2023 to 2027. He builds his professional career in journalism, starting in 1998 as he co-founded Revista Talitakum, wrote in Tetum Forori Otasori Wine, hope I pronounced it correctly, sir, and later served as Director General of Timor-Leste Radio and Television from 2004 to 2006. He also held leadership roles in media governance, serving as President of the Timor-Leste Press Council from 2016 to 2020, and again in 2021 and 2022. Ladies and gentlemen, the Honorable Virgilio da Silva Guterres. Sir.
Thank you, moderator. I adopt to stand up because it's a way to fight against the freezing ambience of the room. Excellencies, distinguished commissioners, colleagues, ladies and gentlemen, good afternoon. On behalf of the Ombudsman for Human Rights and Justice of Timor-Leste, or the official name is Provedor de Direitos Humanos e Justiça, I extend our profound appreciation to Komnas HAM, the Indonesian National Human Rights Commission, for facilitating this important discussion. PDAG, as fellow member of SEANF, meeting our annual conference, we have a shared responsibility to tackle this defining issue. I don't have presentation, I have 5-page description here. I will try to present to you. I want to begin my presentation with two stories. The stories that will help us to identify which are the vulnerable groups when we talk about human rights or digital space. The first story is one of sophistication. In 2019, the CEO of a UK-based energy firm received a phone call. The voice on the other end was unmistakable. It was the voice of his boss, the German CEO of their parent company. The caller sounded not just similar, but identical. He spoke in the same slight German accent, the same cadence, the same tone of authority. This CEO instructed his UK subordinate to urgently transfer 220,000 euro, $250,000, to a supplier in Hungary. He said it was for a confidential, time-sensitive acquisition and emphasized the need for the secrecy. The request was unusual, but the voice was so convincing, the urgency so palpable, that the UK CEO complied without question. The money was wired. It was only later, after a follow-up call to the real German CEO, that the horrifying truth emerged. It was all a sophisticated fraud. The voice had been a deep fake, cloned using artificial intelligence. The money was gone, funneled through Mexico, and then vanished somewhere. This was a seasoned CEO leading a company in a nation with advanced infrastructure and cybersecurity. Yet, he was completely deceived. Now, let me start with the second story. One not of sophistication, but of cruel and targeted exploitation. This is a case from India. A couple from a low-income background in a rural village received a message on WhatsApp. The message appeared to be from a government official. It informed them that they were eligible for a substantial government grant worth Indian rupee, approximately to 2,400 US dollars, a sum that could have transformed their lives. To receive this grant, they were told they need to pay a series of upfront fees, processing fees, GST fee, taxes, and legal charges. Over several days, the scammers used a relentless campaign of pressure. They made video calls, present fake government identity cards, and official-looking documents, and create a powerful sense of urgency and authority. Trusting and desperate, the couple did everything they were told. They took out high-interest loans from local lenders. They borrowed from every relative they could. Piece by piece, they sent about 1,800 US dollars to the criminals. The grant, of course, never materialized. The scammer disappeared, leaving the couple not just heartbroken, but buried under a mountain of debt that they had no means to repay. This couple was poor, hopeful, and digitally illiterate. They were targeted precisely because of their vulnerability. These two stories from opposite ends of the spectrum lead me to my fundamental premise today. In the digital age, vulnerability is a spectrum, not a fixed category. The weapon of the digital predator can be a complex AI defense. Therefore, must be both universal and targeted. It requires universal digital literacy and critical vigilance for all, and specific, robust protections for those who stand to lose the most. So the core challenge, the protection of vulnerable groups in the digital space, is like building a house. It requires a strong foundation, solid walls, and reliable roof. Allow me to outline this. Actually, I still have time. First, the foundation is privacy and data protection. For many of us, a data leak is an annoyance. But for a woman fleeing an abusive partner, a data breach that reveals her shelter location is catastrophic. For a political activist, leaked private message can lead to imprisonment. For a child, exploited image circulating online represent a lifelong trauma. We are not just protecting data, we are protecting lives. Ensuring that sensitive information, identity, location, health status, and financial record is shielded from exploitation is not a technicality. It is a fundamental human rights obligation in the 21st century. Second, we must raise the walls, protection from online violence and abuse. The digital space has become a new battlefield for gender-based violence. for the persecution of ethnic and religious minorities, and for the silencing of human rights defenders. We see it in the coordinated hate campaigns against LGBTIQ+ persons, the doxing of journalists, and the cyberbullying that drives young people to despair. These are not virtual crimes. They have real-world, devastating consequences. They create a chilling effect, pushing the most vulnerable out of public discourse. Our response must be twofold: robust, accessible, and safe reporting mechanism that survivors actually trust. Third, we must ensure the House is accessible to all. Digital inclusion and access is a right that cannot be accessed, is a right denied. The digital divide is one of the most significant human rights issues in our area. This divide is multi-layered. It is the lack of a device. It is the cost of data, which is in many of our countries remains a luxury. In Timor-Leste, as in many parts of ASEAN, we face a critical challenge. The breakneck speed of digital adoption is outspacing our investment in foundational IT infrastructure. We are trying to build the highway while the cars are already racing down. This creates a profound paradox. People are coming online, eager to participate, but they are doing so on unstable ground, making them easy prey for the dangers to lurk in the digital world. Fourth, we must install fair and transparent system in the House, guarding against non-discrimination encoded in the technology itself. We are delegating more and more decisions to algorithms and artificial intelligence, but these systems are not neutral. They learn from our world with biases. What happens with a job application, AI is trained on data that historically favored men over women. We cannot allow the automation of injustice. The digital future must be audited for fairness. Now I come to the Timorese context. In Timor-Leste, our journey is unique and urgent. We are a young nation simultaneously building our physical institution, our economy, and now our digital ecosystem. We are, in essence, building the boat and learning to sail in a stormy ocean. Our reality is defined by a gap, the gap between ambition and infrastructure. Our people's desire to connect, to learn, and to trade digitally is immense, yet our IT infrastructure is not growing as fast as this demand. Therefore, our national strategy must be aggressive and multi-pronged. Invest in human capital rapidly and deeply. Enact strong, adaptive, legal, and policy frameworks. For this, I am proud to share a landmark step in our institution. We identify a critical gap, the absence of a specific law for the protection of personal data. We argue that this legislative silence, this omission itself, constitutes a failure of the state to fulfill its constitutional duty to protect citizen rights. So we submit the petition to the High Court, and the court decision was in our favor. The Court of Appeal declared our petition well-founded, recognizing that the absence of a personal data protection law is indeed an unconstitutional omission. We must foster partnership with the private sector. Telecom companies and tech platforms are not passive actors. They are gatekeepers. They have a duty to not only respect human rights, but also actively engineer safety into their products. And finally, let me very clear. This is a battle we cannot win alone. The digital space knows no border. A scammer can forget a victim in Delhi from a server in Manila or beyond. Therefore, at the ASEAN and regional level, cooperation is not a luxury. It is a matter of collective survival. We must move beyond dialogue to action. SEANF led repository and best practice in digital regulation and literacy programs. So we join capacity building programs to our judiciary and law enforcement on cybercrimes. Conclusion, protecting the vulnerable in the digital space is the paramount human rights challenge of this generation. It requires a paradigm shift from being reactive to being proactive. It demands that we build the road, teach people to drive, and install the traffic lights and police force, all at the same time. It is a complex task, but it's not impossible. It requires political will, significant investment, and a unwavering commitment to the principle that human rights are immutable, whether they are exercised in a town square or a digital platform. Let us leave this conference with a renewed resolve. Let us ensure that the digital transformation in Southeast Asia is not a wave that washes away the weak, but a tide that lifts all boats safely and with dignity. And let our NHRIs be the lighthouses, guiding this journey, illuminating the danger, and holding all duty bearers. Let's join the statement adopted today and have a good discussion. Thank you.
Thank you very much, the Honorable Guterres. Sir, the two stories that you have shared, one in Europe and one in India, I would consider that as they are not actually isolated stories, but stories that are happening worldwide. And you are very correct that in order to protect data, there is really a need to protect data so that we could protect one's lives. And you know, the problem with digitalization and artificial intelligence is that they are, I should say, double-bladed sword. One is positive, one is negative. And the criminals or those with criminal minds are making use of this digitalization or artificial intelligence also to their benefit. So let us hope to stand all together to fight these criminals. The last but not the least, our next speaker is the Vice Chairperson of SUHACAM. She graduated with a law degree from the University of Malaya in 1977 and was attached to the Attorney General's chambers as a Deputy Public Prosecutor and the Assistant Legal Director of the Legal Aid Bureau in Sabah branch. She has been actively involved in numerous associations involving women empowerment at the state level. From 2012 to 2016, she was the chairperson of the Women's Advisory Council, which encourages women's participation in the socio-economic and development of the state. She was also the State Attorney General for Sabah from 2013 to 2017. And also I had the privilege to be with our next speaker in Simporna. I think that was 2 years ago. When we had a joint MOA with Malaysia and Indonesia. So ladies and gentlemen, our third speaker, the Honorable Datuk Mariati Roberts. Ma'am, the floor is yours.
Thank you, Your Excellency. It's nice to meet you again in Jakarta. Selamat tengah hari and good afternoon, Your Excellencies, ladies and gentlemen. On behalf of SUHACAM Malaysia, I'm honored to present an overview of child online protection in Malaysia. Can we have it on? Okay. In today's increasingly digital world, children are spending more time online than ever before. for learning, social interaction, and entertainment. While this offers immense opportunities for growth and connection, it also exposes them to new and evolving risks, including cyberbullying, online grooming, sexual exploitation, and exposure to harmful content. As an overview, according to the UNICEF Our Lives Online report, in Malaysia, 9 in 10 children aged 5 to 17 is an internet user, while 92% of students aged 13 to 17 admit having social media accounts. Furthermore, the report also stated that while it comes to child online safety and parental control, 75.5% of parents reported setting rules and limits of internet usage to their children, while 75.4% have closely monitored their children's internet usage by staying near their child while they're using the internet. 71.1% focus on educating and discussing safe internet usage, while only 57.5% check their child's social media account or browse history. In addition, the Malaysian Communication and Multimedia Commission, MCMC, Internet User Surveys in 2020 disclosed that 47% of those aged 5 to 17 use the internet daily. 53.3% of the parents are aware of parental controls. Only 34.4% of parents use parental controls on their child's device, while 45.5% of parents prefer to use rules as opposed to parental controls on their children's device. According to Cyber City Malaysia, in 2017, 92% of students aged 13 to 17 have social media accounts. The COVID pandemic, which requires physical distancing, has served as a significant catalyst for increased reliance on digital technologies among children, purposes of learning, social interaction, and recreation. Online platforms, including social media, gaming, and video communications applications, have provided alternative avenues for maintaining social connections and emotional well-being during periods of restricted movements. At the same time, many children's learning experience were reshaped by the rapid shift to remote education, while technology and virtual platforms serving as substitutes for traditional classrooms and playgrounds whenever available. While the internet offers vast opportunities for children to learn, explore, and express their creativity, it simultaneously exposes them to a large range of online risks, including cyberbullying, sexual exploitation, and other forms of abuse that can adversely affect their mental health and overall well-being. It is therefore essential that efforts to mitigate this risk are balanced with the protection of children's rights to freedom of expression, access to information, and privacy, empowering children with digital literacy, resilience, and other skills to navigate the online environment safely remains a critical background. In Malaysia, the issue of child online protection has gained increasingly prominence within the national agenda, reflecting the government's and stakeholders' shared commitment to ensuring that every child can participate safely, responsibly, and meaningfully in the digital environment. And next page, please. As children become increasingly active in the digital world, whether for learning, socializing, or entertainment, they are also becoming more exposed online risk and exploitation. From cyberbullying and grooming, or exposure to harmful content and misinformation, the digital space can often mirror and sometimes magnify the inequalities and dangers children face online. Among the cyber threats faced by children in the digital space are cyberbullying, cyber grooming, identity theft, child pornography, and exposure to violent graphic content. According to the Ministry of Women, Family and Community Development, Investigations conducted between 2017 and August 22 identified 106,764 IPs addresses suspected of involvement in child pornography. The harm caused to child victims is unspeakable and enormous. The mental and emotional development of the victim is severely impaired and requires a longer recovery stage that will affect the social well-being. The harm caused to child victims includes victimization through child pornography, means that victimization never ends. Images placed on the internet can never be fully erased or recovered. Images continue to be passed from person to person indefinitely, and many users of child pornography amass large collections. Immediate effects on child victims are physical injury and pain, including sexually transmitted diseases, feelings of shame, unworthiness, anger and confusion, somatic responses, withdrawal and isolation, anxiety, depression, and the like. Long-term effects also cause depression, as well as worthlessness and low self-esteem. Distorted and unhealthy sexuality, this difficulty establishing healthy relationships are among the other consequences. Greater risk of getting ensnared in commercial sexual exploitation, ongoing humiliation, and lack of privacy. Next page, please. The next cause of concern is online child sexual exploitation and sextortion. Children in Malaysia are vulnerable to online sexual exploitation, with some being stuck in the loop of sextortion. The MACC has taken down 640 online sexual abuse materials for children from 2023 to 2024. And sextortion is a form of blackmail in which someone threatens to distribute private or sensitive material, such as sexual images or videos, unless the victim agrees to specific demands. One research indicated that at least 4% of Malaysian children are active users of the internet, have experienced 4 types of sexual exploitation. The first is that they often give some money to say sexual photos or videos of themselves. And the second is that they often gives or perform sexual acts in person. The next one is sextortion, where they would blackmail the children. The last one is that they would contact the children again and threaten them that if they don't share their nude photographs, they would spread the photos of their parents and school friends. Children do not want to disappoint their parents, so they would again and again concur with perpetrators. Next page, please. International studies have shown that repeated exposure to violence can lower empathy, increases aggressiveness tendencies among adolescents. A study of the University of Michigan entitled Media Violence found that teenagers frequently exposed to violent media were 37% more likely to exhibit aggressive behavior. For example, in October 2025, it was reported that a 9-year-old boy in Johor, Malaysia, stabbed his younger brother, aged 6, allegedly over disrupting the game of Roblox. Roblox has long been criticized for its lack of safety controls and protection for minors. Next page, please. On cyberbullying, according to a report by UNICEF, Malaysia ranks second in Asia for cyberbullying among youths, behind China. On a global scale, Malaysia is ranked 5th after Peru, Argentina, Mexico, and Brazil, reflecting the seriousness of the issue in Malaysia. Next page, please. Malaysia has passed several regulations and laws to address this issue of sexual abuse against children online. And the first legislation is the Sexual Offences Against Children Act 2017, which sets out specific offences in respect of child pornography, grooming, and sexually communicating with a child. Section 19 of the Act imposes a general obligation to report information of the commission or intent of committing sexual offences against children to an officer of the nearest police station. And failure to do so is an offence. and the Act brings strengthened legal protection to child victims of sexual violence, including those that take place online. In addressing this issue, the evidence of Child Witness Act 2007 have been amended, with the Child Witness Amendment Act 2024 taking effect on March this year. Key amendments include establishing the Act as the primary legislation for child witness testimony, allowing convictions based on a child's testimony without corroboration in certain cases. Technological advances have brought growing threats to children online. Therefore, the new amendments are imperative to keep up with the current times and technology. Next page, please. Yeah. Yes, the Penal Code and the Criminal Procedure Code too have been amended to include wide range spectrum of behaviors, including verbal abuse, threats and harassment, cyberbullying, and doxing to be considered as an offense. And Section 57D, for example, provides for penalties up to 10 years imprisonment. Next page, please. We also have enacted this year the Online Safety Act 2025, designed to create a safer online environment for regulating harmful content and establishing responsibilities for online service providers. The Act, officially gazetted in May this year, includes measures to protect children, combat online fraud, and make harmful content inaccessible. And we also have the Online Safety Committee set up recently, also having the same intent to regulate what is going on online. And I think we can also go to challenges and opportunities. Next page, yeah. One challenge is that technology evolves faster than the law, making enforcement and accountability difficult. Another is cross-border jurisdiction, making online crimes involving actors operating from different countries. So I'll conclude with going into Suhakam's recommendations to the government. Our first recommendation was to establish a national hotline especially dedicated to addressing child abuse, child exploitation, and child pornography. And the government was also encouraged to establish national data system on internet usage by children to monitor the category and age of children using the internet. And the government has also need to prioritize children, collaborate and generate collective action among relevant ministries to prevent and address all forms of violence against children. And the government is also to amend laws to mandate internet service providers to block, delete, and report offensive content involving child abuse and exploitation. The government needs also to have a legal framework that would ease the identification of suspects using ICT devices through IP addresses, detection, destination and source of communication to commit offenses against children. The government is also to take proactive measures to prevent discrimination based on sex, disability, and socioeconomic background, ethnic or national origin. And we also ask the government to ensure that in all actions regarding the provision, regulation, design, management, and use of digital environment, the best interest of every child is a primary consideration. And the Ministry of Education should also create guidelines for schools and parents on their roles. And as for the stakeholders, next page please, we encourage an ongoing awareness campaign that should be conducted to educate parents and children on internet safety. Both parents have to play a bigger role in the matter. And for parents and caregivers, we advocate that children should think, they have to educate their children to think before they share. No personal details such as full names, schools, or locations should be made in public. Parents should also talk to their children, and having open, judgment-free conversations is the best defense against online exploitation. Talk about sextortion, online dangers, and let the children know that they can always come to their parents without fear in getting trouble. And parents, guardians, teachers, and schools have the role to create awareness and instill knowledge regarding digital space at the age when children have access to their phones. And in closing, next page please, at the end of the day, technology must serve humanity, not harm it. Protecting the children means ensuring that the digital space remains inclusive, safe, and rights-respecting. Government, NHRIs, civil society, and the tech industry must work together to make sure digital progress goes hand in hand with human dignity and equality. Thank you for listening, and I do apologize for the cough that I'm nursing. Thank you.
Thank you very much, the Honorable Roberts. In your presentation, I was really struck by the statement there wherein the Malaysian government has addressed that the child online protection has gained increased prominence within the Malaysian national agenda, which reflects government stakeholders' shared commitment. And also you have highlighted problems or the vulnerabilities of our children. I think every region, and here in the Southeast Asia has this problem. Let me just share that November is Children's Month, and in the Philippines, we celebrated the National Children's Month with the theme, Online Sexual Abuse and Exploitation of Children, and child sexual abuse and exploitation materials should the dissemination should be ended, and that the rights and of children should be highlighted. Solutions really to the problems are, as shared to us by the Honorable Roberts, is through legislation, amendment of laws, and creation of safety committees which would look after the welfare of our children. So that concludes the presentation of our panelists. The floor is now open to questions. If there are questions, please raise your hand, kindly identify yourself and your organization for proper acknowledgements. Are there any questions from the floor? Yes, ma'am. We have I saw a hand raising at the back.
Hello, good afternoon, ladies and gentlemen. I am Arba from Compliance Service Komnas HAM. I would like to ask especially for Datuk Mariati Robert from Suhakam. Okay, I'm Arba from Compliance Service Division of Komnas HAM, and one of my daily tasks is receiving online complaints involving risk to children in the digital space, such as cyberbullying, sexual exploitation, exposure to harmful content, and other related issues. I would like to ask that, from your perspective, what is the most urgent step Indonesia should take to better protect children online? That's all. Thank you very much.
Thank you for your question. I think basically while you have legislation, control should begin at home. Because legislations can only do so much. Because eventually the parent or a guardian would be responsible for the conduct of the child. So I believe that that should be the first step. Maybe you should make legislation making perhaps parental control of the child's involvement in online to be a legal requirement. That could be the first step. Okay? And the number two would be getting the schools involved as well. So your legal framework should be very comprehensive, getting the whole of family, school, and country involved. I think the Malaysian Act, like the Sexual Exploitation Act, Prevention, sorry, I'll just get the name right, okay. Sexual Offences Against Children Act, Children's Act, 2017, it makes Section 19 makes it a requirement for anyone who knows anything about online expectation of a child to make a police report. And actually, it's an offense not to do so. While I admire this, I always believe that perhaps it should start from the home, from the school, and then the community. And the other thing, I think that you should also make it easy for a child to lodge a complaint. I think one thing we have the very bad habit of making things very complicated. So there should be a simple online form of making a complaint, make that known to children and the schools and even the parents. So everyone gets involved. Because as we all been saying, online bullying is something that cross borders. Strangers making all kinds of comments will hurt a child, that kind of thing. Okay, I think that's the answer I can give you for now. Thank you.
Does that answer your question, ma'am? Okay, thank you very much. Any other questions? Yes, Atnike.
Thank you, Mr. Chair, for all the speakers in the front. Thank you for a very diverse presentation on the issue, considering the vulnerable groups, threats or also challenge towards the vulnerable groups in digital space. The concept of digital gap is often understood as the lack of accessibility towards internet or digital technology. But having your presentation, I could elaborate further that digital gap is also the vulnerability that people do not understand about what will happen when they access digital space. While technology has been advancing faster than the digital literacy, what can NHRIs do in promoting slow advancement of ICT or internet? I think there is no way that everyone, especially vulnerable groups such as children, indigenous people, migrant workers, poor people, remote area, could follow the fastness of digital technology. If we look at the current social policies procedures, many of them are become digitalized. If you enter Indonesian immigration now, it's all digital. You have to have mobile phone with you, with internet access. So what will happen with people who do not travel with mobile phone, or if they travel, they don't have internet access? Something like that. Also, social policy, social security policies, they are mostly now digitalized. So what will happen with those who do not have access? I think it is time for National Human Rights Institution also to remind government that acceleration of technology cannot be done without considering there are some people who may not accelerate as fast as others. So there should be analog procedures, you know, in policy, social policy services, any services provided by government, it cannot be all digitalized. From what I understand from experiences, like transferring money, school applications, work permit, and so on. I would like to hear your response on this matter.
Thank you very much, Atnika. Maybe we could start with Mr. Jafar, and then move to the Honorable Ombudsman, and then the Honorable Roberts.
Yeah, thank you for the question. Before I respond to the question from Ibu Atnika, I will give the additional information about the first questions, because Indonesia, after amendment of the Information and Electronic Transaction Law last year, the law putting the one of the article about the children protection in the digital space. And last year also, in the early of this year, the government also released the new government regulation on the protection of the children in the digital space. But the problem is the government regulation still need of the several subsidiary regulation in the level of the ministries, including the digital platform must be developed of the several standards to implementing the concept of the safety by design as a mandate from the regulation in the level of the technical levels. How the digital platform providing the algorithms, including the content something to protect of the children in the digital space. And last month we have the case. It is so up about the intersectionality of the issue of the digital space for the vulnerable groups, I think, because it is a case related with the bombing case, but conducted by the senior high school student, because the senior high school students bullied by the friends, his friends, police in the schools, and the child accessing the online gaming, how to develop the bomb, also to establish the bombs, use of the YouTube something, and they are creating the bomb and the explosion of the bomb in their schools. It is because the offline situation, how the child bullied by his friends, but he has the access from the network, how to create of the bomb, use of the several materials. And they refers to the several case by the perpetrators from the case of, for example, Christchurch in New Zealand. The another case as reverence, as examples why he used of the bombing strategy to retaliations because he built by his friends. It is the case in Indonesia, the actual case. And for the response from the Ibu Adnika, last night, Pak Marzuki Darusman at 11 p.m. texting me because he worried the government will be release the new policy to mandatory SIM card registration, use of the biometric data. Pak Marzuki said it is too scary for me as a citizen, because there is no strong protection of the privacy something. How if the government's use of the data to the political purposes something, how the government's control of the population use of the biometric data something. Pak Marzuki is elderly people, but he worry about how the use of the technology and in these periods. So I think currently, because technology magnitudely expand to all of the lives, we need of the collaborative works within all of the stakeholders, including the NHRI, to develop of the several strategy. Because in Indonesia, based on my observation, especially, there is no systematic models of the digital literacy. It is just ceremony event, how conducted of the seminars, public discussion about the digital literacy, but there is no systematic models of the digital literacy, including involving of the NHRI. Even though in Indonesia, all of the social services, they need of the digital platform, they need of apps, because the government has the program to conduct of the digitalization of the identity. So all of the citizens must be installed of the digital identity apps in their phones to access of the social services from the governments. But it is not considering of the situation, for example, the indigenous people's community or the people without of the digital, without the identity, And yeah, so it is what is creating the new social exclusions and the new models of the discrimination to the peoples because they cannot access of the social services or the public services from the government. So I think the NHRI must be involved in all of the process, including how the NHRI providing the policy recommendation in all of the process of the debating of the formulation of the legislation and the policy, including how the NHRI providing the guidelines for the public, how the use of the human rights approach to access of the digital devices, digital access something, also providing of the specific models of the compliance to response of the use of the digital technology impacted to the violation to the vulnerable groups, for example. So I think the NHRI has the modality to developing of the several strategy, including also collaboration with the digital platform, because the digital platform, I think the need of the strong approach use of the human rights standards to continuing or sustainability in their business in this situation. So I think the NHRI has the opportunity to developing all of the models of the strategy to involve in the response, providing the safeguard in the use of the digital technology.
Thank you. Thank you very much, Mr. Jafar. Next, we have the Honorable Virgilio da Silva Gutierrez, and maybe, sir, you can now also give your final message so that we will finish a bit within the allotted time given to us. Thank you.
Okay, in my presentation, I mentioned about our national strategy. One is to invest in the human capital. But any innovation or any new development always produce what we say the collateral side or damage for it. I remember when the first desktops arrived in the editorial rooms of the media. The journalists, the old generation that were usual to the typewriters, they hate the desktop. They love to write the stories on the typewriters. But we don't throw the typewriter at the same time, at that time. But we need to prepare the next generation to be adaptive, to know how to be secure in using the new technology. I think if we consider the digital development also contains certain virus, we should know how to produce the vaccine. And the production of the vaccine only happens when we know how the virus works. So for that, the government, the state, all of us, we are responsible in guaranteeing the education for all. So people, we not just produce, like I say, not just we produce IT graduates, but also generation of cybersecurity experts, data scientists, AI ethics, talk about ethics. That's the only way we can. I have, with my wife, we have some rules from our kids before COVID. No phone during the school days, only on the weekends. But during the COVID, the need for online schools, online learning. So we were advised by the teacher, please, parents, please facilitate with your kids some Android or laptop for them for online. So you need to prepare for this. So the only thing is to guarantee that we not get lost in the labyrinth of this digital cave. I think this Greece mythology about that hero going to kill something in the labyrinth. So he got the help from this queen of the spider to provide him a line of thread, a tie in his back to go to the dream, so he can identify the road back. So now I think we need that line to tie on us. What is that line? The knowledge of the digital world, the ethics, for that, the code of conduct, the mechanism that we need to, so we do not get lost in that labyrinth. I think that's only my message.
Yes,
Thank you.
Thank you. Thank you very much, the Honorable Guterres. Then we now have the Honorable Datuk Mariate Roberts, ma'am, for maybe a reaction and your short final message.
Okay.
For the panel.
Yes, thank you. When Dr. Aniki mentioned that comment about the elderly, I cannot help but smile because I am a baby boomer and I have problems sometimes catching up with all this digital stuff. And I even learned one word today, technophobia. That is what I think we should be addressed, especially for those in the rural areas. Because to the elderly, to the baby boomers, it can be scary. So I think patience is needed when you deal with the elderly on this issue, especially those in the rural areas. Sometimes we forget that connectivity might not be that good over there. And they might not have young people to assist them. Because most of the time, the elderly would seek assistance from their children and vice versa. Okay, that's one. Since I've been talking about children and their rights under online safety, I still think over and above, parents should have better control over their children on this issue. There's only so much that the law can do and control that the government can make. And then, of course, parental communication with their children should always be there. I think over and above, when both parents are working, the father would be passing the burden on looking after children on the mother and vice versa. So parents need to take accountability of where their children are heading. I think eventually that is my bottom line.
Yes, thank you very much, ma'am. Truly, we really need, there's this saying that it takes a village to raise a children, so we have to help each other to raise our children, the future of this generation. So maybe that would be the last question, ma'am, from Atnika. I think that's the best question ever because it has addressed or elicited answers on all issues. No? And before I would give my concluding statements, let us all give a round of applause to our prestigious and very honorable speakers. So if there is one thing common in all of this presentation, it is the need for collaboration among NHRIs, civil society organizations, private sectors, specifically telecom companies, and the government to continue advocating for a strong legal framework or mechanism that would respond to the challenges presented by new technologies. Let us all remain committed to a future where technology serves to uphold human dignity and equality. Thank you very much for your time.
Thank you very much to Commissioner Epres and all the speakers. Please give the big applause. Ladies and gentlemen, a significant moment has arrived. We are about to read the SEANF Conference Statement on Human Rights in the Digital Space. Please, may I invite Chairperson Anis Hidayah from Komnas HAM, Ombudsman Virgilio da Silva Guterres from PDSJ of Timor-Leste, Chairperson Pornpai Ganjanarit from NHRTC, Chairman Pauline Sain from NHRC. Commissioner Monina Arevalo Zendarosa from CHRP. And Vice Chair Datu Mariati Robert from Suhakam. Please, to all the speakers, come to the stage. And we would like to invite Mrs. Anis Hidayah, the chairperson of Komnas HAM, to deliver the statement.
Good afternoon. I will read the conference conclusion on human rights in the digital space, emerging challenges and the role of NHRIs. Welcoming the convening of the Southeast Asia National Human Rights Institution Forum, SEANF conference, under the theme of Human Rights in the Digital Space, Emerging Challenges and the Role of National Human Rights Institution. We, members of SEANF, who participated in Southeast Asia National Human Rights Institution Forum Regional Conference held in Jakarta, Indonesia on 18 November 2025. Reiterating the vital role of the National Human Rights Institution in the promotion and protection of human rights in their respective countries as well as the regional and international levels. Recalling international human rights instruments, including the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social, and Cultural Rights, and other relevant United States treaties and frameworks on human rights in relation to the digital space. Recognizing that the rapid growth of the Internet and digital technologies present both opportunities and challenges for the promotion and protection of human rights in Southeast Asia region. Acknowledging that civic space has expanded into the digital realm, offering civil society new opportunities to promote and to protect human rights. However, recent trends indicate challenge to online expression and growing incidents of digital attacks against human rights defenders. Concerned that the rapid development of the information and communication technology, ICT sectors, may negatively impact the enjoyment of human rights, including through breaches of data privacy, arbitrary restriction on access to information, and biases or discrimination embedded in algorithm system and artificial intelligence, among other risks. Alarmed by the growing harm of digital abuse against vulnerable groups, including online gender-based violence, exposure of children to harmful content and cyberbullying, online sexual abuse and exploitation of children, as well as the rise of online scam and cybercrime, all of which constitute human rights violations. We hereby announce the following recommendation to the follow-up based on each SEANF member's mandate and legislative frameworks. The first, encourage governments to promote and guarantee protection of human rights in regulating the use of digital technologies as such to implement adequate safeguards to prevent and mitigate potential risk and to provide effective remedies for victims of human rights violation occurring in the digital space in accordance with the national laws and policies centered on human rights and international human rights treaties norms and standards. Second, youth government to respect civic space in digital space, including freedom of speech and expression and data privacy, and further encourage government to conduct effective investigation into human rights violation occurring online, particularly those targeting human rights defenders. Third, call upon the governments to enhance the capacity and mandate of national human rights institutions to effectively address the fast-changing and multifaceted developments in digital space, which increasingly influence the enjoyment and protection of human rights. Fourth, invite national human rights institutions and civil society organizations across Southeast Asia to closely monitor and integration of human rights principles into government digital policies while providing necessary support and recommendation to ensure their effective implementation. The last, call upon business enterprises in ICT sector to conduct comprehensive human rights due diligence and impact assessment as the UN guiding principle on business and human rights across their product and services. Take proactive measures to mitigate digital vulnerabilities, develop and implement ethical and non-discriminatory programs, and uphold the highest standard of transparency and accountability and in all businesses operation. Thank you very much.
We may now take a moment for photographs. On my count, in 3, 2, 1. Please once more and give your best smile. In 3, 2, 1. Please give the big applause. Thank you very much. To all distinguished delegates and respective colleagues, we are in the end of the agenda and we would like to inform you to fill the evaluation form which could be accessed in the link tree as feedback to us. As we come to the end of today's, we would like to thank to all respective colleagues for your valuable insight and engagement. We hope this meeting has been enriching and inspiring for all. My name is Milenia Patricia. I would like to take my leave from all of you, and I really apologize for any shortcoming or mistakes. Good evening. Wassalamualaikum warahmatullahi wabarakatuh. Om Santi Santi Om. Namo Buddhaya. Salam Kebajikan. Rahayu.